We'll be here at a memo, so just run late.
It's 2 p.m. on November 8th, and I will call the Code Enforcement Board meeting to order. Madam Clerk, would you please call the roll?
Mrs. Archer,
Here?
Mr. Weeks,
Here.
Ms. Dabbs is coming later, okay. Mr. Kramer,
Here.
Mr. Robinson,
Here.
Ms. Norfleet.
Here.
Yeah, I'd like to ask Attorney Trask if he would please give the invocation and lead us in the Pledge of Allegiance. Would everyone please stand?
Heavenly Father, we seek blessings on the tasks before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decisions with impartiality. We pray that our work this afternoon will find favor in your sight. This we pray. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I will now read the Code Enforcement Board hearing procedure. It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the circuit court. Such an appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal. The procedure of this board is as follows. First, the city presents its witnesses and exhibits, after which the alleged violator is able to ask the city's witnesses any specific questions regarding their testimony. Secondly, the alleged violator is allowed to make a presentation and present his or her witnesses and exhibits. Then the city can question the alleged violator's witnesses. After both rounds of testimony, both on the part of the city and the part of the alleged violator, each party is asked to give a closing argument, first by the city and then by the alleged violator. After those three steps are taken, this board will close the public hearing portion of the case to discuss it and take appropriate action. Before we begin the public hearings, we will have all potential witnesses please stand up and be sworn in by the secretary of the board. So if you're going to be speaking today, please stand up and put your right hand to the.
Do you swear the testimony you're about to give is whole truth and nothing but the truth?
I do.
Thank you. Please be seated.
And we ask that you please turn all cell phones to silent. Thank you. We have a Okay, what number? Under old business, first one.
Item 36.
To accommodate those in attendance who wish to be heard before the board in regarding their case, there will be a modification of our regular agenda to hear the following cases first, and they will be in this order. We're first going to take under old business number 37.
Actually,
Then
36.
I'm sorry,
36.
36. Then number 1, number 5, number 2, 18, and 17. So we're going to 36 under old business. Request for foreclosure. It's case number 16-8000375 at 127 North Gross. James C. Vars. Is it co-owner?
Care of.
care of Rebecca Vars Ebert. Everyone get there.
Excuse me? He raised his hand during the. Yes.
Okay.
Yep. Okay.
Thank you. All right. Thank you.
Officer Gaston,
Yes, ma'am.
you have anything you'd like to say?
Thank you. This is a request before the board to proceed with foreclosure on a code enforcement lien. The case being referenced is 16-800000375. Property owner James C. Veras, care of Rebecca A. Veras Ebert. It's at 127 North Gross Avenue.
Let me go through the rest of the case.
So let me just give you a little bit of background, just so that you know and understand what's going on here today. Under your rules of procedure and under the city's code, if the city wants to move forward with the foreclosure of a code enforcement lien, they have to get permission from you first, and then they'll take it to the commission, city commission, to get permission for the city commission to move to foreclose this property. This lien evidently has been in existence for going on 3 years, and there are some specifics as to the reasons why the city wants to move forward. As a matter of due process, they're coming to you for that first step of the request. That request was provided to the daughter of the deceased owner, and she is asking for a continuance. She doesn't say when she wants it continued to or what's going to happen if the continuance is granted, but she's just not available to be here today, and I guess her husband is here on her behalf to speak on her behalf. So you got two issues to deal with. One is do you want to continue the hearing? And if so, when do you want to continue it to? If you don't want to continue the hearing, then you need to determine whether or not that you want to authorize the city to begin the foreclosure process on this property. And this should be in your packet, the information relative to the property itself and the reason why the city is moving forward. I believe that's a letter from Officer Gasson on police department letterhead.
Excuse me, to what packet do you refer? I don't have a packet.
Sir, if you want to, you can step up here. I'll be able to hand you what the code. Can you provide him a copy? Okay.
And I can answer any questions that obviously the board may have as far as specifics and background that Mr. Trask.
We can't hear you, Steve.
Okay.
You need to speak right into that microphone.
Sorry.
Go ahead and speak in so everybody can hear you.
I was just advising that if you have any questions about the specifics that Mr. Trask had kind of mentioned, I can answer those questions.
Just to explain the address business, Rebecca Veras Ebert is currently a student at Duke Divinity School and didn't receive these until something came to Ocala in the last 2 weeks. To answer your question, Rebecca Veras Ebert would like a continuance for the purpose of obtaining a lawyer to represent her in this matter. She's been talking to communicating with Ms. Taylor, but she hasn't been able to reach Ms. Taylor recently. I don't know quite where Ms. Taylor is right now. I myself have mailed as well as emailed and have gotten no response. In terms of a timetable, as soon as we get in touch with a lawyer, which could be as soon as next month, we'd be ready to proceed.
So Officer Gasson has the opportunity now to, I guess, present whatever he wants on the case, on whether or not it's important to move forward now or some future date. So you wanna tell the-
Basically, this case has been going on since 2016. The property is a hazard. It was actually condemned by the city. There's numerous neighbors that are frequently complaining about this property. It's structurally unsound, it's dangerous, and it's a hazard. And that's the reason why the city wants to move forward with the foreclosure. And the city's position at this point in time is not to allow any continuance and to move forward with the case so we can bring this property into compliance and basically demolish the building. Unless, of course, they're able to get the building demolished in a timely manner, that would bring it into compliance, which would solve the problem as far as compliancy goes. But it is probably one of the more significantly dangerous properties I have in the city right now that I'm dealing with. So that's the reason why we're here, and that's the reason why the city is requesting that we not continue this and we move forward with foreclosure.
The board have any questions for Officer Gasson?
There was a question here about it being related to another historic home.
We confirmed today, actually over the last 2 days, it's not in a historic district. It may be old, but it does not qualify under the U.S. Department of the Interior for parks as a historic, in the historic district. So it's not protected in any way, shape, or form as far as that goes. Like I said, it just may be old, which I'm pretty sure it is old. The other thing, just for the board to kind of help them out, I had numerous conversations via email up to a certain point with the daughter of the Mr. Various, and then suddenly she quit having conversations. That was over a year ago. So she was aware of the situation. She said she wanted to get it demolished, wanted to move on, but then she just kind of disappeared off the face of the earth, for lack of a better term. Didn't resurface until we started the foreclosure process. So, I think it's fairly obvious where we're at now. So, and the property's not getting any better. As a matter of fact, I think even one of the neighbors showed up to complain about it. So that's the city's position.
If I could speak,
Go ahead.
I'm competent to testify on certain communications between Vera Siebert and the city of Tarpon Springs, as I was personally present. Ms. Vera Siebert was informed that her house was part of the historic district and there would be a problem in destroying it. So Vera Siebert has communicated and tried to get a resolution of the matter. This is the first I've heard that there's a definitive statement that it's not. Now, for those of you familiar with Gross, this was a carriage house for the house across the street, which I believe is in the historic district. Again, if we get a clear signal from Tarpon Springs that there's no issue with this being a historic district house, we have no problem taking it down ourselves. But again, we've gotten mixed signals, and I am testifying on my own knowledge as far as that goes. I was there.
I
Yes.
don't think I understood that. You said if it is part of the historic district, you're willing to take it down.
No.
confused.
If Tarpon Springs represents, as they've just done, that it is not part of the historic district and will be held harmless, we have no problem. The trouble is we've gotten mixed messages. As I said, I was present when we were told it was.
By whom?
I don't know. I'd have to look in my records. This was a few years ago. But that's part of the reason there's been a delay, the ambiguity that we might have to restore the house. And again, there's an ambiguity in that the house across the street probably is in the historic district.
We have a historic preservation board, and its whole purpose is for that. So if these attempts have been made, the property can be brought before the historic preservation board, and they can either acknowledge that it can be demolished, or they can acknowledge what would need to be done to it, but those steps haven't been taken, and even he mentioned this is 3 years now. So there's been no application to HPV for preservation or demolition, and they're the ones that would approve it if it does fall into the historic. I'm not an expert by any stretch of the imagination on historic properties. I go by basically a fancy Google map, and it's not beyond me to be wrong on the fancy Google map. So, but that's why we have the Historic Preservation Board, and it can be applied to them. If it's foreclosed, if we foreclose on our lien, the city obviously would follow whatever procedurally they have to as far as a historic property. So, but some still can be demolished, but they have to be with the approval of the Historic Preservation Board if they fall into that category.
As far as you know, they haven't been asked about it, or they don't know
Well,
anything
you
about
go
it?
you go through a process with them. I mean, they hold a board meeting and properties are discussed, and we've got nothing back as far as that goes.
Excuse me, just for clarity, I want to ensure you all understand. We were told it was part of a historic district, not that we had to apply for it. We were told it was. And again, that's
you
part
don't
of the
know
reason for the delay.
If it was someone from the Historical Society, you don't know who.
Somebody right here in this building told us that.
Okay, let me just jump in. It doesn't have any relevance. The question is the property in compliance or not, and what actions are going to be taken to bring the property into compliance? Obviously, the property owner has not taken any action in the last 3 years. They need to, if they believe that it's historic, they need to have an application before the Historic Preservation Board and address the issue of either rehabbing it or demolishing it. They've done neither. And the city just can't sit back and wait to have them decide when they're going to go ahead and bring the property into compliance. It's one of the worst properties in the city, as the Officer Gasson has already explained to you, and nothing is being done. The only reason that the city moves forward to foreclose properties is when the property owner is not taking responsibility for the property. And that's the question here. So, I mean, if you wanted to move forward to get the property into compliance, there's two things that you can do. You can grant the continuance and give them a specific period of time to apply and bring the property, go through that historic preservation process, or you can give the city the authority to begin the foreclosure process. So either way, there needs to be a deadline. It can't be one of these situations where it just sits out there. The property is not being maintained, and it is dangerous, according to what the officer has said. So those are your options as I see it, as the board's attorney. So,
All right. Does the board have any other questions for about this case, Officer Gasson? If not, we're going to close the public portion and look for a motion.
I move based on the testimony, evidence, and facts presented by the law that at the time of the alleged violation, sections 133.02, 8-40, 8-52, the Code of Ordinances of the City of Tarpon Springs were in force and effect, and the respondent was in violation thereof.
Second.
okay, we've already passed that point. That motion was made in 2016, and it was found to be in violation then. The question here is, do you want to give the city the authority to foreclose or not? That's the motion. I move to authorize the city to foreclose, or I move to grant the continuance that's been requested and set a hearing date for sometime in the future. Those are your options. They've already been found in violation 3 years ago of those code sections. So that's what the request is here in Officer Gasson's letter. So we need to maybe reword the motion to reflect, if you want to, that they're still in violation and authorize the foreclosure, or still in violation and grant the continuance for a date certain for them to apply to the HPB board.
I move that based on testimony, evidence, and facts presented by law, at the time the alleged violation sections 8-40, 133.02, and 8-52 of the Code of Ordinances are still in violation and force and effect. Respondent is in violation thereof, and I request a foreclosure.
Do we have a second?
Second.
Any discussion? Roll call.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
No.
Mr. Weeks,
Yes.
Mrs. Archer,
Yes.
motion carries.
Okay, so if I can just wrap it up then. So, Mr. Ebert, the Code Enforcement Board has authorized the request to foreclose. The next step would be it would go before the City Commission for approval for request to foreclose. You have the opportunity to appear at that commission hearing if you want. There will be no specific notice to you, so make sure that you keep aware of what's going on the agenda. If you want to appear and discuss that at the commission meeting, the mayor may or may not allow you to speak on that issue, but that's the next step. My suggestion to you is to start the process immediately to apply to the Historic Preservation Board to either obtain that demolition permit or find out if you need to rehab it and start the rehab process. And that may play a strong point in the direction as to whether or not the City Commission is going to authorize the foreclosure.
I have 2 questions. My understanding of the testimony was that the structure is not in a historic district. Is that correct?
Sir, you can talk to the city after this meeting, and you can specifically go to the planning department and speak to the planning director and have all your questions answered relative to the historic structure or not, whether it needs to go before the board or not. But this board only determines those issues that are before it, and the request has been heard by the Code Enforcement Board, and they have acted. So at this point, the next step for you to gather information is from one of the city departments and not this Code Enforcement Board.
Okay, so just to clarify, that's not a finding of fact of the board.
No, it's an authorization to foreclose.
Okay, second question, is this a final administrative order that is appealable to the circuit court?
You can appeal any decision to the circuit court if you would like. Any decision that's made by this board, there will be a order that will be issued authorizing the foreclosure. You'll have 30 days under Chapter 162.10 to file that appeal.
Okay. Thank you, sir. Now we'll go to number 1. Case number 18-80000573 at 1702 Mexico Avenue. Genesis Andreas and William Frito. Someone here?
No, I don't believe so. It's Shannon's case as well.
Oh, okay. All right. Go ahead, Sam.
This is case 18-80000573, 1702 Mexico Avenue. I'm Shannon Brewer, currently employed by the City of Tarpon Springs. I'm an ISA certified arborist, license number FL9221-A. I'm also an FNGLA certified horticultural professional, license number F978402. All photographs and exhibits that were given to the violator are exact copies of what's being presented to the board. All notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and the tax collector databases. All NOVs and NOHs are certified return receipt and first-class mail. Please accept all exhibits into the record as evidence.
Yes. Bob, would you please receive those when they get here?
Yes, ma'am.
Thank you.
July 24th, 2018, Greg Dobbins, an ISA certified arborist, license number FL6609A, also employed by the City of Tarpon, was called to by the neighbor to the east because of a dead tree was leaning over the property line towards the neighbor's home. Greg confirmed that there were 2 dead trees and they were hazardous. He sent a courtesy letter the same day. August 15th, 2018, a reinspection was completed by me. The dead pines were still on the property, causing the property to be out of compliance. The NOV was mailed the same day. September 19th, a reinspection occurred. At that time, additional trees were dead. An amended notice of violation was mailed to the property on record and to a Miami address supplied by utility billing the next day. September 25th, the amended NOV addressed to Janesi Andres and William Prieto at 1702 Mexico was returned to the office, missing the green card and no stamp from the post office stating why. October 10th, the reinspection occurred again, and the dead pines had not been removed. The center pine has dropped a large amount of bark and large limbs, and they were observed piled up against the fence. The property was still out of compliance. The NOH was sent October 22nd, certified first-class mail. The NOH signed a post, and the affidavit of posting was October 22nd. The final inspection was conducted November 7th. Again, there was no change to the property, and no permits had been obtained. The middle tree had lost even more bark and limbs, and onto the top of the home. The property is out of compliance. This concludes my evidence.
Board have any questions for Shannon? Anything you'd like to summarize?
No further.
All right, so we'll close this portion and we'll entertain a motion.
I move that based on the testimony, evidence, facts presented by law, that at the time the alleged violation, sections 133.02 of the Code of Ordinances, the City of Tarpon Springs was in force and effect, the respondent was in violation thereof.
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes. Now we're gonna go to number 5.
Oh, we need to do the second portion of the motion. The
I'm trying to hurry it up.
fine state and the fine.
Okay, we need another motion then for the
I move that the respondent shall have until December the 8th to bring the property into compliance in Code 133.02 or suffer a fine of $25 a day for each day thereafter and the remain violation of said section.
Is there a second?
Mr. Kramer.
Yes.
Any discussion? Roll call.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes. Number 5. Case number 18-800000528 at 131 East Oakwood Street. Mark and Joyce Weddick. Would you please give us your names and your relationship to the property?
Joyce Weddick, owner.
The owner?
I'm Joyce's son,
Your name, sir?
Matthew Weddick.
Do you have any objections to the clerk receiving documents and photos into evidence?
Yes, because this property was zone IB originally, and in 2011, when the rules changed, that's when we fell non-compliance, I guess. And I guess recently you just picked up on it and said that we're not in compliance.
Okay, so the question was whether or not you have a legal objection to the photographs and other evidence coming in to evidence. And so it's either a yes or a no, and if it's a yes, you have an objection, you need to state your legal objection, like it's irrelevant or it's hearsay or another legal objection.
Okay,
No. You'll still have the opportunity to answer questions and present your case and use those photographs if it's helpful to you.
okay.
So any objection?
No, I don't.
Okay, thank you.
Thank you, sir. Officer Gaston?
Thank you. Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. This is case 18-800000528, property address 131 East Oakwood Street, property owner Mark and Joyce Wedig. Exhibit number 1 going before the board are all of my photographs that I've taken, including the inspections. Exhibit number 2 are all of my notices, including notice of violation and notice of hearings. Exhibit number 3, any administrative docs to include case summary, property appraiser and tax collector records, and any related emails. Exhibit number 4 is the affidavit of posting and a copy of the sign. All the photographs and exhibits that were given to the violators are exact copies of what's being presented to this board. All notices were mailed to the property owner of record. It's determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearings are sent certified return or receipt as well as first-class mail. And Madam Chairman, please accept these into the record as evidence.
Yes. Bobby, did you receive those into evidence?
Yes,
Okay,
ma'am.
Thank you.
This case started July 24th and conducted the initial inspection at 131 East Oakwood. That's the address of the property. It's a fenced-in lot. There's no structure on it. Along the alleyway east of Pinellas Avenue on the north side of Oakwood. So if you're familiar with that area, there's an alley, and this is a fenced-in lot on the east side of that. Apparently, the lot at this time is zone T4B. Previously, per planning and zoning, and I have an email from Patricia, who unfortunately couldn't be here. She was here the last time on the other property. So she kind of explained some of the stuff as far as zoning, because that's not my area of expertise. So, and she stated previous zoning was general business. The outdoor storage is allowed, but only by conditional use. What that basically means is the lot is currently full of a combination of watercraft, personal watercraft, cars, there's a forklift, and I think there may be a storage container. And that was what the nexus of the complaint was. We were unsuccessful at finding any conditional use, which would have, in order to store the other vehicles and things like that, the property owners would have had to have gotten a conditional use for the property. So it's being used outside of what it's allowed to be used for. At that point in time, it appears to be a junkyard or a salvage yard, which requires a conditional use in industrial categories. The property was previously zoned commercial, and none of our commercial categories allowed junkyards or salvage yards. Basically, at that point in time, we sent notice of violation on July 25th requesting that items being stored in the lot which are non-conforming or contact planning and zoning and obtain conditional use for the property. Regardless, it's not necessarily allowed to be used for outdoor storage. On July 29th, I conducted a reinspection and there was no change. On October 9th of this year, a notice of hearing was mailed, first class and return receipt. I posted the property on July 29th. On November 7th, I conducted a final inspection, and some of the vehicles that brought 419 into compliance, and they're owned by the same people, they brought it into compliance, but they moved some of those vehicles into the storage lot at 131 East Oakwood. So there's now additional vehicles inside that fenced-in area. The fenced-in area is for outdoor storage, if it even qualified as it requires opaque fencing. It doesn't have those. What's before the board right now is a violation of the conditional use 209.00 and also 57.00. I'm gonna, if there's not a problem with it, some of this is an excerpt of what Pat had sent to me via email, and is also part of the record. She states, and she also sent this to Matt Wedick, who I assume is you. Okay, so Matt also got this, but basically she stated on November 7th at 4 o'clock, at the last Code Enforcement Board hearing, the board asked that I research the previous zoning on that property, 419 South Pinellas. The previous zoning was general business. The zoning allows outdoor storage only as a conditional use. We do not have any records of the conditional use as we discussed. There was probably never an application for it. That may be why the business tax receipt has a restriction requiring all the storage to be on the Oakwood property. So there's a business tax receipt in play that has specific conditions on it. With respect to the Oakwood Street property, the storage unit or area is restricted to wave runners, as the business tax receipt states. I would consider this to obviously include the forklift needed to move the wave runners and the wave runner trailers on which they sit. Storage of automobiles, machinery, scooters, and other items we discussed was not included. as we discussed, you could apply for a conditional use to upgrade the storage area to include these items and to meet the applicable code sections. Once you complete your next step at code enforcement, let me know what you want to do. Next step is here. Based on that, part of their conditions of their business tax license was what that property could be used for. So what's before the board is they failed to get a conditional use as required. And then the definition of outdoor storage under 57.00, one of its requirements requires that you have opaque fencing. Even if the conditional use, the zoning is a moot point, 57.00 is still before the board because there is no opaque fencing around the property. You can see from the photographs that I submitted. So, but 209.00 covers the requirement for conditional use, and 57.00 is what covers the outdoor storage, and that's what I have before the board at this time.
Board have any questions for Officer Gass?
Now, I have a comment.
No, just a minute.
Okay.
How long have you noticed this, or has this been going on a long time, where all these cars and everything else has been there?
Yeah, it has been going on for a long time, and there was even a 2003 case for the outdoor storage. I don't know what the result of that is without looking it up, but so that puts us 15 years back that there was an outdoor storage issue.
So right now, they're only allowed to have wave runners?
And based on what Pat said, like the forklift to move the wave runners into trailers and things related to it, not vehicles, not scooters, things like that, not cars.
But the fence is supposed to be opaque.
Under 57.00, the fence is to be opaque. That's one of the requirements for outdoor storage. There may be some other zoning issues that I'm not aware of, but that would be the whole process through planning and zoning, which would give them all their conditional uses and what they would be allowed to do.
Sir, do you have any questions at this time for Officer Gass? Give your statement.
Yes. Like you said, the 419 property use, we had the vehicles there.
A question?
Yeah. What restrictions at 419 do we have?
419 is not in discussion here.
It's tied together, though.
No, this is 131 East Oakwood we're talking about. That case is closed. You're in
I
compliance.
understand, but what I'm getting at is I had vehicles at this one. There was no restrictions for outdoor display until 2011. You're saying I can't have vehicles here, so guess what? I should move them back to 419 for display again?
I can't tell you to do that. We're not discussing 419. We're discussing.
But 419. Okay.
You want to go ahead and state your case now, sir?
Do you have the fence permit with you? I tried to get a copy of it. I couldn't get a copy.
I'm not required to have a copy of your fence permit. You're not here for a fence permit issue.
I understand, but they instruct us not put the opaque up on it. And this angle right here, they instruct us cut off the angle so they could see through it to make right-hand turn. Well, actually, before it was the opposite direction when the roadway was. So our fence was actually cut at an angle, which you guys went out and you staked it, which I proved that I was further out. And then you guys had us cut at an angle, and we were instructed not to put 57 opaque up. And that's probably what it was 2003, too.
Is it a question or a statement?
Okay. What was a 2003 violation for storage then?
Stand by, I'll tell you.
Huh?
Stand by a second, I'll pull it
okay.
up. This could take a while because apparently the address didn't exist back then, so I got to look it up by parcel. So give me a couple minutes. Or we can move on with some other stuff and I'll try to find it.
Understand. I didn't know it even had an address, so I understand.
The city's able to address parcels, so it makes it easier in the system.
While he's looking that up, does the board have any questions for Matt? Is that your name?
Thank you.
He can present the rest of his case while we're waiting to answer that question.
Is there anything else that you'd like to present with?
DMing.
This has just been totally confusing to me. I don't know about to the board, but at the last hearing for 419, Officer Gaston said it was confusing and they were tied together. And today, when we're trying to
Tie him back.
talk about one and it's tied to the other, he says, we're not here for that one, which doesn't make any sense, because if you talk about one, you have to talk about the other. I just don't understand. The other thing I didn't understand was we kept getting letters to Mark Wadick, which I'm assuming you are thinking this is Mark Wadick. Mark Wadick is dead and has been dead for over 5 years, and Officer Gaston knew that. And I do not understand why he would send mail to Mark Wadick. Mark Wadick could never respond to anything here. That's a fact.
Is that a question or a statement?
That's a statement.
Okay.
Well, ask him if he knows.
I guess, why were you sending mail to Mark Wadick?
It's a listed property owner according to the tax collector and property appraiser's records?
No,
Okay, well,
it's not.
you might need to discuss that with Pinellas County then, ma'am, because that's what we use as our records. So,
I think you were misinformed. It seems also, can I make statements or only ask questions?
No, you can make it.
We've had these licenses since the year 2000. It was the most industrial type license we could get at the time. I think it was called industrial business or intensive. We have had them continuously, consecutively. The city has accepted our money for the renewals every year without saying anything. This is all news to me. All of a sudden, I think there's a different wording on the new license this year, which came unexpectedly. I don't know why or how things just change without notifying us, but it seems like that's what happens. I mean, we didn't get a letter, we didn't get a phone call. I've lived in Tarpon for 38 years. Quite a few of you know me. I'm pretty local, and I just wasn't expecting anything to be different this year than any other year. Just that's about it, that things just seem to change and we're never notified.
just for your information, I did pull up the property appraiser's record, and it says Mark Wettig and Joyce Wettig, 419 South Pinellas Avenue, 4131 East Oakwood. So you might need to discuss that with the appraiser's office, but that's who they show, and that's who we send it to, just to, so you understand that.
Okay.
As far as the 2003 case, you know, there's issues in here with the prior zoning, which I think Mr. Wettig was going to bring up about it being IB. And at that point in time, it apparently was zoned IB. And part of that previous case was also no site plan. Well, that was put into compliance because apparently they did come up with a site plan. Beyond that, I'm not exactly sure what resolved out of that. You know, the notes aren't incredibly extensive as far as that goes, but the issue still remains as far as the business permit having specific specificities, which would require a conditional use application. That part, I don't know what wording may have changed over time. Do you have a previous business license?
I've got one right here. It says storage of wave runners, and then no restrictions at 419.
Okay,
Which
but
means I can put
what's
vehicles
at,
back on 419.
what's at 131?
131,
Which
it
is,
says storage of wave runners.
okay,
But it also was zoned IB when we came and talked to them, and I'm sure that's what it was 2003, is that you can have outdoor storage, extensive storage of vehicles, heavy equipment. What else did it say? The IB district is established to provide an area of intense commercial activity involving major repair service, extensive outdoor storage, or the display of vehicles, heavy equipment, or materials, and to provide light manufacturing where permitted by a comprehensive plan.
And when did that change?
2011, whenever you changed our IB.
Okay. And you have a business license, it says,
Since 2000,
since 2000 what?
since 2000.
Oh, since 2000, which stated no, just wave runners.
Right, and then we
Okay.
talked to the board in 2003, and it was brought up and addressed then.
Okay, but your business license was never changed. So
Correct.
you're
They
just,
said we didn't
and do you
need
have a
to
copy of
because
that
it
business
was
license I could see?
applied under the district of IB.
Okay.
Sure. Oh, yeah. Here's the IB, what it says, and the licenses.
I don't need the ID stuff. So the license states storage of wave runners at 131 East Oakwood.
Correct, so that means the vehicles need to go back out 419, which you're saying.
We can discuss 419. That's not
No,
part
no,
of this.
no,
Hold on.
they're tied together.
No, they're not. We are dealing with two separate properties.
Same
So,
business, same two licenses, same business.
okay.
They're both Jet Speed Sports, same company.
Are they separate parcels?
Yes, they are.
Okay. Thank you.
But-
Are you entering a copy of this?
No, you
business tax
have
license?
that copy.
Okay. Can I enter the, or it's his, but I would like it entered into the record. Is that possible? Okay, go ahead. Just 131. Oh, these are both for 419.
No, that's what I'm saying. If you read the comments, they're
Oh, no, this is fine. This is fine. That one. This one I don't need. No. So this is the business tax license that also includes 131 East Oakwood that has the specific restrictions of wave runners only. So. Which still, according to city ordinance, requires a conditional use to change or modify.
but that changed in 2011. Is what the code changed.
But your business tax license states storage of wave runners.
Right.
That is what your tax
Okay,
license
fine.
states.
You can say that all you want. Do you want me to move the vehicles from 131 to 419? I mean, I guess I want to come in compliance is what I'm trying to do.
I can't answer that question here. We're discussing 131. I told you we can discuss your options after this case is heard.
So then we're back here again in a month? I mean, I just want to get
If
it
you
resolved now.
violate the city code, potentially, yes.
But
So-
it's not, because at
Okay.
419, there's no restrictions, I'm saying.
Is there some point when you can tell us?
Not here.
No.
We can certainly discuss it when this is over with because it's not part of this code board hearing, is what I'm trying to explain to
How come
you.
last month you got to tie them together?
That didn't come
We
on.
didn't because we never
Yes,
heard
we did.
131
Yes,
East
you
You
Oakwood.
said they're adjacent.
Okay,
You
we've got to stop this.
requested that.
What you can do is get with Officer Gasson after the meeting or tomorrow or something and discuss this other property because that's not what is brought before us today. And we can only discuss what is brought before us. So we're going to have to go on with that.
Didn't do that last month.
Just
That's what we're going on with today, ma'am.
wait, it's industrial use property.
Benny,
I don't have anything
Summer,
further.
or they were just, do you have anything else you'd like to just talk
You
about?
give them the copy of the actual 2611, I think.
No,
Why not? Well, can you please do that?
you can present it.
You've got it.
Well, we'll give it back to you.
Do you want to tender that into evidence?
Yes.
Okay. Any objections to that coming into evidence? Okay.
I'm not. I was just asking. Yes, I'm frustrated.
Of course,
Okay.
I am too.
You want to tell Bobby to receive that?
Bobby, will you please receive those when you get them? Yes, thank you, and Evan. Officer Gaston, do you have anything to summarize?
No, I think we've established, well, yes, actually. We've established their business tax license says that that property can only be used for a specific purpose. It's not being used for that purpose. And in order to use it for that purpose, they must obtain a conditional use. And that's basically what's before the board. As far as 57.00, if something changed between 2003, 2011, and currently, that again is something that could be handled through planning and zoning to see if they do need to get a site permit and if those requirements are necessary or not, which at that point in time, if they're not required by planning and zoning, that offense would simply be brought into compliance and it would be a done issue. As far as the business tax license, the exact same thing. If they go through, get a conditional use, get it clarified, whatever the case may be, then they're in compliance. The issue is basically a paperwork issue and what the property use is about, and that's what's before the board.
Did you ever find out what the
Hold on a second,
2000?
sir. No. We're not going to do that anymore. So he has summarized his case, and now you have the opportunity to summarize.
Summarize. You can't ask any questions. You just summarize. Anything else you'd like to say about it?
I guess we're still waiting here on 2003 violation, because if that was the same thing, then it's already been addressed.
Now, this
That's
is
what I'm saying. If it's been 2003, it's already been addressed and heard.
This is a violation under a new case, 18-8, and then there is 40528, in violation of City Code Section 209.00 and City Code Section 57.00. This is not in relation to the 2003 case.
Okay, what were those violations? I mean, I'm just trying to make sure that we're not repeating ourselves 5-10 years again from what those were.
Sir, this is not your dog and pony show. This is a quasi-judicial proceeding. There is a process that we have to follow.
Okay.
And so we're at that point in the process where you have the opportunity to summarize your testimony or anything else that you want to say, and then the board's going to close the public hearing and decide what they're going to do. So anything else that you wanted to add?
The only thing I can say is we were instructed that we did not need to put the opaque up in 2000 when we had fence. We had cut it at an angle so they could see through. So if we tie those two things, they wanted it at an angle so they could see. That's why they said don't put the opaque, because it would block their view anyways. I mean, we were instructed when we got the fence permit that we couldn't do that. I mean, they came out, inspected it. We actually had a 4x8 sheet of advertising on it, and we had cut off 2 inches off the bottom of it originally because I guess the square footage, because of the angle, they miscalculated when they cut the angle that we're not allowed to have 2 inches on the bottom. We had cut 2 inches off.
Okay.
I guess I'm done. I mean,
Okay.
Okay, this public portion of the case is now closed, and board, we will entertain a motion.
I move based on the testimony, evidence, and facts presented by law that at the time the alleged violation, sections 209.00 and City Code 57.00, the Code of Ordinances of the City of Tarpon Springs was enforced in effect. Respondent was in violation thereof.
Can I have a second?
Second.
Any discussion?
Yes.
Go ahead.
What I heard, I think, this particular case is only concerned with the storing of vehicles against the code. He was just mentioning something about a fence, which has nothing to do with this. Am I analyzing this correct? This is strictly storing of vehicles in a place where the code says you can't.
In addition to that, there is Code Section 57.00, which requires the fence to be opaque. Though that's the case.
Okay, so that still is a violation then, the fence?
That's what the city is moving forward on.
Okay.
Yes.
Okay. I'm clear now. Thank you.
Any other discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
No.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes.
Okay, so now we need to do the compliance date and the fine. Okay.
Do you have a recommendation for compliance date?
I
Fine.
understand they need to go through the city departments to take care of this. So based on that, I would think it's reasonable to ask for 45 days to try to take care of that. Their prior violations are minimal, so $25 a day. It's not a, you know, it's been going on for quite a while, so it's not a hazard per se.
Okay. All right. Need a motion?
How much was the per
20.
day?
20.
I move that the respondent shall have until December the 8th to bring the property into compliance with code sections.
At 40.
45 days? Oh, let me start again. I move that the respondent shall have until December the 22nd to bring the property into compliance with city codes 209.00 and 57.00, or suffer a fine of $25 per day for each day thereafter the respondent remains in violation of said code.
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
No.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes.
You want me to summarize it? So the Code Enforcement Board has found you in violation of sections 209.00 and 57.00. You have until December 22nd to bring the property into compliance. Should you fail to bring it into compliance within that time frame, there will be a $25 a day fine. If you don't understand what has happened today, feel free to talk to Officer Gasson after the meeting. You will receive the order in the mail. It should be about 10 days. Within the next 10 days, you will receive that. So I guess the other direction that we would give you is to move forward with your application with the city for the conditional use and get some clarity relative to the outdoor storage.
Okay.
So,
Yes.
and you can do that through the planning department.
Okay.
Good luck.
Thank you.
Okay, number 2. Case number 15-2000006 at 40839 US Highway 19 North, Lake Tarpon Church of Christ. Signed in, didn't you? Yeah. Mr. Boyer. Please give me your names and your relationship to the property.
My name is George Levy. This is my son, Justin Levy. And behind us is John Montega. John represents the church that is under the code violation. However, we're the issue. We're the next door neighbors, the owners of the plaza.
Do you have any objection to probably the gentleman there to documents and photos being received into evidence?
I need to jump in.
Okay.
You don't own this property.
No, sir. We have a relationship with the church. The issue with the property is he's generous enough to allow us to use the property for parking.
So you're a tenant of the property then?
But the representative is here from the church. He is allowed.
I got that. I just want to make sure that this board understands who is who, because ultimately it's not going to be you that's going to be responsible if they find it in violation. It's going to be the church. Okay. Sir, you understand that?
I do.
Okay. And your name again, John?
John Montagna.
Mortega?
Montagna. Montagna.
Okay, thank you. Okay, I'm sorry I interrupted you, Madam Chair. So the question that the chair has asked, do you have any objection to the documents being received into evidence that have been provided to you today? No. Okay.
Thank you. And Bobby, if you receive those in evidence, please.
Yes, ma'am.
Officer Gaston, we're ready when you are.
Thank you. Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. The case is 15-2000006. The property address is 40839 US Highway 19, known as the Lake Tarpon Church of Christ. Before the board right now, exhibit number 1 are all of my photographs to include my inspections. Exhibit number 2, all the notices, including the notice of violation and notice of hearing. Exhibit number 3 are administrative docs, case summary, property appraiser and tax collector records, as well as associated emails. And affidavit 4 is the affidavit of posting and a copy of the sign. That'd be exhibit number 4, not affidavit number 4. All the photographs and exhibits are given to the violators, are exact copies of what's being presented to the board. All my notices are mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearing are sent both first class as well as return receipt requested. And Madam Chairman, please accept the exhibits into the record as evidence. First off, let me try to get you guys to understand why this is a 2015 case. Originally, the case was started internally by the building department. Anthony Mastraccio, when he was the building inspector here, started the case, had gone through a process in November of 2015, November 18th, 2015, asked the code enforcement department to send a notice of violation for section 6-1, which is our city ordinance that adopts the Florida Building Code. At that time, it was the 2015 version of the building code. He then cited section 105.1 of the Florida Building Code, which is failure to obtain a building permit for work being done. On November 18th, notice of violation was mailed, certified in first class. A reinspection was conducted, not by me, I believe it was by Anthony. He stated they're currently going through the process for a conditional use and attending the Planning and Zoning Board next month. They're currently working on it. September 2nd of 2016, per Anthony, stated that he will have to discuss the case with Heather in Planning and Zoning to obtain information regarding parking. June 26th of 2018, after Anthony left, we found files and cases, and that's where this one kind of resurfaced. So we were revisiting it. We realized it was still a violation. So spoke with Heather in Planning and Zoning, was told all they need to do is complete the site planning process, and we sent an updated notice of violation at that time. So in effect, for me, this case started June of this year is kind of my process. It just fell to the wayside for the previous 2 years. We mailed out the notice of violation June 26th. On July 13th of this year, spoke to Planning and Zoning. There was no permit or any visit from the owner or representatives at that time. Final notice of violation was mailed out in July, certified and first class. Unfortunately, the staples threw my date, so stand by for a second. August 1st, I conducted a reinspection. No permits have been obtained. No one's come into the city to start the process. At that point in time, I scheduled it for a hearing. We mailed out a notice of hearing, first class and return receipt, and we started to have some conversations with folks, so we deferred the case from September's code board until obviously now. They started the process of working through site planning and other things through planning and zoning. And like I said, that started finally in September from when they originally got the case back in 2015. Included with the board's evidence is a number of emails going back and forth, especially between Pat McNeese in Planning and Zoning, because obviously I kind of hand these things off a little bit to them to deal with all their conditional use and things like that. And I'm sure they can probably provide a little bit more information as far as the process that has been going on with Planning and Zoning. Long and short of it, the reason why we're here is there's still a functioning parking lot in violation of city code. There's still not a permit been issued for it. There's still not a site plan that's moved forward. The last conversation I had via email through Beth was that we requested they close off the parking lot, and then at that point in time, all of the paperwork issues, planning and zoning and everything could be taken care of, because technically they're still profiting from the illegal parking lot for 3 years, and the city's position is secure the parking lot so it can't be used until permits are obtained, it's properly taken care of. That was not an option apparently, so I went ahead and brought it before the code board to basically establish a definitive timeline to get this process taken care of and bring this property into compliance. So what's before the board at this time is violation of City Code 6-1. Again, our code's been updated, and if you look at the current 6-1, it's adopting the 2017 Florida Building Code and the 2018 IPMC. At this time, it was the 2015 because the case did originate in 2015. Section 105.1 of the Florida Building Code hasn't changed over those 3 years, and it basically requires that any work being done requires a building permit. We don't have a building permit, so that's the actual violation at hand, is before the board is the violation of not having a building permit. And that's all I have at this point. Oh, just for the record, all of the mail was returned unclaimed. Obviously, at some point in time, somebody got some mail because there's some folks here, so, but other than that, we never got any of our return receipts.
Board have any questions for Officer Gasson?
Is the building permit the parking lot? Is that the building?
To do any kind of work like that under the Florida Building Code, you have to get a building permit. There's some other things they weren't cited. You'd have to submit a site plan. You have things like that, and they just weren't cited for that. It was a very simple: get a building permit, give it a permit issued by the city to allow you to do the work that you did, or that it's supposed to be intend to do. In this case, it's been done, so it's kind of like getting an after the fact permit.
Do you have any questions at this time for Officer Gasson? Just questions?
I have no questions. I have commentary, but I have no questions. Is that
Yes, you can go ahead and
I
give
have
us
a
your-
question, actually. You said we received an email from Beth stating that we were told to close the lot.
yeah,
I know I had conversed with either.
No, you're not. You haven't been sworn.
I conversed with Beth, asking that I basically wouldn't bring it before the board and we could extend the timeout if the parking lot was closed off. And I was told that that wasn't an option. So then I went ahead and we're here. So
yeah, we were never informed. But if you give me,
we would have probably told the owners of the property. I'm not necessarily responsible to communicate with people that don't own the property. I mean, it's just the legal part of it.
I understand.
And that's the reason.
You want to go ahead and state your case now?
Sure. First of all, we agree with probably a very large percentage of the comments made. But I'd like to give you a little bit of history because it's a little bit of an odd situation. And I have some notes to keep me on track. So we purchased this plaza back in 2015, and I'd like to think we were one of the first to take a risk in the city of Tarpons because back then it was a complete eyesore on 19, and there was no other renovations being done at the time. So I'm the one who spent over $3.5 million to bring Tarpon at least back when you drive into the city to look halfway decent. And the tenants, you know, with their investment, we're probably talking about $5 million. Well, with that success of getting good tenants in, not massage parlors and not the hookah bars, I really took the time to get first-class tenants in. Came to success, and with success comes challenges, and the challenge for us was parking. So what we were told, legally, you can let people park on the streets, it's okay, it's legal. And we thought, well, we want to be here for a long time, and we'd rather not make the 8 o'clock news having people getting hit on the streets, because the business that brought us the most business is Mugs and Jugs, and it's a nighttime entertainment spot. And with the fact is, we wanted to have people safer, but we can't have them parking in our lot because it just didn't fit that kind of a crowd. So the church is kind enough to allow us, we had an agreement, if we maintain the lot, they would allow us to park there, and that's what we've been doing. And we've spent probably about $10,000 to date, and the gentleman's correct. We first met with we first put in a parking lot because we didn't it's not a building, it's not even a parking lot, it's an excess parking area. So we did move forward and did what we thought we needed to do. And Heather and her team did come up to us and say, what are you doing? And we did meet with them back in 2015, and we came up with a sincere plan. And we knew we needed to start with a permit. And then to be 100% transparent, the lot was done the way we thought it would look proper. Nobody from the city was harassing us. We moved forward, and here we are in 2018. And this is just the truth. And my son, who's now managing the property, I was over to the plaza about right before September. I said, Justin, the church lot doesn't look really nice to me. Let's resurface it or at least get it cleaned up. And by the way, I think when we get a permit, they were telling us we needed to push the ropes farther out to the street. And the reason I didn't put them there to start with is because I didn't want people to park on the street on the other side and cause risks. So we moved the ropes, and it's interesting that you found the file, because I thought because we decided to spend more money and clean it up and move the ropes is what woke everybody up to say, oh my God, this has never been resolved. So we're here to basically just ask if we could have, and we have been working with Heather and Pat, and the reason it's been delayed since September is we've been waiting for a couple of answers, like what the surface should be. Is it okay to be shell? So we've been waiting on some final answers now that we raised the flag again to get this accomplished. And we just got those answers Monday. We actually were hoping for a few clarifications, but then we realized we better come here or else. So we're here admitting that we should have done what we should have done in 2015. But if we could have 90 more days, we will get the permit and get the details laid out. Our understanding is we need to get a permit, we need to get the survey done, and with a site plan, and then there's just a few things we have to get accomplished. But we really ask you, please don't stop parking until that gets done, because, you know, quite frankly, there hasn't been an accident reported in 3 years. And I think it'd be a real shame if this committee closed it for 90 days or whatever, and an accident appears and it all comes back to that. So if you give us 90 days, hand on heart, we'll get it done as long as we get cooperation, and it'll be finished. So, like the last gentleman, I'm done. Thank you.
Okay. All right, board have any questions for the gentleman? Do you have any?
I don't have any questions.
How does the church feel about that, sir?
We are totally, we just want to help, community. We have that piece of land just vacant. So that's what we offer. Instead of having the vehicle like we saw before they approached us, we actually saw the street. When they approached us, that's a fantastic idea. That piece of property there. That's our.
And we're just trying we're trying to spend as little funds as possible. I'm not prospering. One comment I said I agreed with almost everything. I'm not prospering from this. We don't have to spend the money to do this. We could let everybody legally park all over the streets. So we're not prospering from this. I don't get paid by anybody to do this. We're spending our funds, quite honestly, to keep the community safer. I admit we didn't follow the rules from day one. Part of it is because it's just a parking lot. It's not a building, and it wasn't even a real parking lot. So we thought it would be okay, but we admit.
Thank you, sir. Officer Gaston, do you have anything to summarize?
No, I think it's pretty well covered. I appreciate it. Thank you.
Do you have anything else you'd like to summarize?
No, ma'am. Thank you.
So the public portion of this case is now closed, and we'll entertain a motion.
I move that based on the testimony, evidence, and facts presented by law at the time of the alleged violation, Section 6-1 and Section 105.1 of the Code of Ordinances of the City of Tarpon Springs was in force and effect, and the respondents were in violation thereof.
Need a second?
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes. Officer Gaston, do you have like a recommendation for a time frame or daily fine?
Understanding that this is the church that is the actual violator, and the fact that if these guys don't go through with what they're saying, the church is the one who's going to end up being fined with this, is the only kind of trepidation I have. I originally would have kind of gone with 45 days just to expedite it, but the city would actually be punishing the church, so to speak, although it is ultimately their requirement. So with all that being said, I think I'll go along with the 90 days. And as far as fine goes, I think probably $25 a day is reasonable considering all the circumstances.
Ready for a motion?
I move that the respondent shall have until February the 6th to bring 2019, to bring the property into compliance with codes 6-1 and 105-1, or suffer a fine of $25 a day for each day thereafter the respondent remains in violation of said code
Second.
section.
Any discussion? Roll call, please.
Ms.
Thank you.
Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks.
Yes.
Mrs. Archer.
Yes.
Okay, to summarize, the church has been found in violation of those two code sections, 6-1 and 105.1. Church has been given until February 6, 2019 to bring the property into compliance, or suffer a $25 a day fine thereafter.
You say
Thank you.
2018?
19, I'm sorry, if I said 18, it's 19.
19.
Okay.
All right, thank you.
Thank you.
We're gonna go to number 18 now. The repeat violator in violation from 9/28/18 to 10/6/18 for 9 days. Case number 18-800000791 at 802 Francis Drive, Catherine Bauer Estate. Hello.
Hello.
Please give us your name and your relationship to the property.
Anthony Bauer. It's my deceased mother's home.
Do you have any objections to documents and photographs being put into evidence? Or
No, ma'am.
Bob, if you receive those,
Yes, ma'am.
we're ready off the gas. Can you?
1 second.
Sure.
Okay, I'm ready, ma'am. Sorry. Ready? Officer Gasson, Tarpon Springs Police. This is a repeat violator case from September 28th of this year to October 6th of this year for a total of 9 days. The property is currently in compliance. The case number before the board is 18-800000791. The property address is 802 Francis Drive. And Catherine Bauer's estate is listed as a property owner. All the photographs include the inspections are exhibit number 1. Exhibit number 2, all of my notices, including notice of violation and notice of hearing. Exhibit number 3 is administrative docs, case summary, property appraiser, and tax collector records, and any associated emails. Affidavit number 4, or exhibit number 4, is the affidavit of posting and a copy of the sign, and exhibit number 5 is the affidavit of prosecution costs. All the photographs and exhibits were given to the violator, exact copies of what's being presented to the board. All my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearings are sent, returned, receipt, certified, as well as first class. And Madam Chairman, please accept these exhibits into the record as evidence. This case started September 28th. The property was overgrown and not being maintained. On that same date, the repeat violator notice of hearing was mailed certified in first class. On October 9th, the property was re-inspected and it was mowed, and it's in compliance as it is today. I posted the property sometime in October, I think. October 29th, sorry. I posted the property, and the affidavit of posting was signed. We did get the mail returned unclaimed, but we have had contact with the owner via email. We have his email address since we communicate frequently now. So he was made aware, I think, via email about the property. So basically what they were in repeat violator for was 8-40, duty to maintain private property, and 8-52, the nuisance prohibitions, which deals specifically with mowing and upkeep of your lot. And just for the board, it was established under case 17-8000788 for these same 2 violations plus another one. It was a previous repeat violator case, 18-8000336. Under that case, there were no fines done for that repeat violator case. So now this is the third one. They have a neighbor that's very concerned with this property because I've had numerous cases that resulted in no violations, but he has had, now this will be the second repeat violator case for this property. So that's all I have at this time.
Board have any questions for Officer Gasson? Do you have any questions at this time for Officer Gasson?
No, ma'am.
You want to go ahead and state your case?
Yes, ma'am. It's clear that this was overgrown. There's no doubt about that. I live in Indiana, and I want to apologize for having to appear before you yet again for this property. I know the board showed extreme forbearance in the last time this property was before you, and I appreciate that. We are doing our best to maintain the property. I contacted my lawn care company today to request that they start mowing the grass on a regular basis. It had not occurred to me that despite the tropical climate, the grass would grow quite this fast. So it was very definitely out of compliance, and there's no question about that. I understand the neighbor's concern about this property. It has a long history with the Tarpon PD. Fortunately, the people that caused that history, my mother, she's deceased, and my nephew is now a guest of Pasco County, and hopefully will stay that way for some time. But I'm doing all that I can at this point to maintain the property as best I can from 1,300 miles away. But as I said, I have taken the steps to make sure that the grass maintains at a reasonable level so that this is not an issue going forward. As soon as we can get the probate issues solved and have an estate created, it is my intention to liquidate this property so that it is no longer an issue for the city of Tarpon Springs. We're having a great deal of difficulty getting the paperwork filled out. I'm having trouble finding out the date of the deceased for my great-great-uncle who died long before I was born. There's no instructions for the paperwork for this sort of thing, and I can't afford an attorney for that purpose, so I'm having to kind of do it on my own, and it's been a little difficult, so that's why the property is still in an estate and not sold to someone else.
The board have any questions? Mr. Gaston, do you have any questions?
I do not.
I asked you, but I meant to ask, is there anyone living there at this time?
Not at this time. There was a possible complaint about someone having stayed overnight a few weeks back. Actually, it was the date that we received the notice from code enforcement. And I had contacted Tarpon PD that day and asked them to go out, and they searched the property and found no evidence of anybody having broken in, but there's clear signs that they'd mentioned a hole. Turns out that hole was caused by an air conditioner that had been stolen from the property. So, yeah.
Anything to summarize?
No, ma'am. Thank you.
Do you have anything else that you'd like to summarize?
No, ma'am.
Public portion of this case is now closed, and we'll entertain a motion.
Move that based on the testimony, evidence, and facts presented by law, that the respondent was in violation of sections 8-40 and 8-52, the Tarpon Springs codes, from the date of 9/28/18 until the date of 10/6/18, and a fine of $100 a day for 9 days, fine of $900 total. In addition, I move that the city be awarded $84 for costs incurred at prosecuting the case.
Do we have a second? No second?
May I ask the person making the motion, why it's $100 a day? I mean, why?
Because it's a repeat violator.
It dies for the lack of a second. We need another motion. Yeah.
Need another motion.
I move that based on the testimony, evidence, and facts presented by law, that the respondent was in violation of sections 8-40 and 8-52 of the Tarpon Springs Code from the initial date of 9/28/18 until the compliance date of 10/6/18, and a fine of $50 per day for 9 days, a fine a total of $450. In addition, I move that the city be awarded $84 for the cost incurred prosecuting the case.
Second.
Any discussion? Roll call, please.
The second was, I apologize.
Sunny. Ms. Norfleet.
Norfleet, thank you, I'm sorry. I was reading. Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Thank you.
Sir, the property owner has been found in violation of those two code sections, 8-40 and 8-52, for those 9 days. The board has established a fine of $50 a day times 9 days, a total of $450 plus $84 in costs for prosecuting the case. Just for your own information, the Code Enforcement Board had the opportunity to fine up to $500 a day for each day of it, and so that is quite lenient. So the order will be coming in the mail within the next 10 days. Do you have any questions?
No, sir. I just wanted to thank the board for your understanding.
Thank you. Okay.
Good luck, sir. Now we're going to 17, number 17. Repeat violator.
Appreciate that.
In violation from 10/9/2018 to 10/22/2018, 14 days. Case number 18-800000589 at 314 East Harrison Street. Janie Mae Williams. Repeat violator.
I think so. Jeff went that direction.
Ma'am, would you please state your name and your relationship to the property?
Janie Mae Williams, and I live at 320 East Harrison Street, Tarpon Springs.
That's the
And I own the property at 314. And the rest.
We have documents. Do you have any objections to the city documents or
No, ma'am.
pictures being put in
No,
for evidence?
No, ma'am. I'm sorry.
Bob, if you receive those, please. Officer Gaston.
Thank you. This is a repeat violator case from October 9th, 2018 to October 22nd, 2018. The case number is 18-800000589. The property address is 314 East Harrison Street. Miss Williams is the property owner. The case number for the repeat violator case was 18-8000274, which is a violation of City Code 8-52, and she was established under that case number. Exhibit number 1 before the board are my photographs and my inspection photographs. Exhibit number 2, my notices, including notice of violation and notice of hearing. Exhibit number 3, administrative docs to include case summary, property appraiser, and tax collector records, and any associated emails. Exhibit number 4 is the affidavit of posting and a copy of the sign. And exhibit number 5 is the affidavit of prosecution costs. All the photographs and exhibits are given to the violator, exact copies of what's being presented to this board. All notices were mailed to property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All the notice of violations and notice of hearing are sent both certified return receipt as well as first-class mail. And Madam Chairman, please accept these exhibits into the evidence as evidence to the record. Thank you. So the case started August 13th of this year. The only thing the board is hearing is just the repeat violator. Everything else was in compliance that I'm going to talk about, but I'll give you the background. The lot was overgrown. There was 4 inoperative vehicles and other debris on the property. There was some pepper trees that need to be removed and some vines and things like that. They were overgrowing the property. There was a name change in October, so a new notice of violation, notice of hearing, and a repeat violator notice of hearing were sent out October 9th after the clarification of the naming was taken care of. On October 23rd, I conducted a reinspection. The only thing that remained on the property, which isn't in the photograph, was a little crashed Nissan. That's since been removed, so that's not before the board anymore. On October 29th, I posted the property. So on October 23rd, it was in compliance, but she had contacted our office on October 22nd to state that it was in compliance. So that's the reason why October 9th to October 22nd is our time frame of 14 days. Conducted the final inspection for the Nissan. Kind of conducted a couple of them. I conducted one yesterday, and it was still there, and then went back by and today, and it was gone. So that put that whole thing finally in compliance. We have had contact with the owner, and we did get all of our paperwork that we sent via certified mail returned to us, signed. So as I stated, the only thing that's before the board is the 852 repeat violator. And I'm not moving to ask the board for to establish on any of the other violations. So just consider the 852 violation for the 14 days it was out of compliance. And that's all I have at this time.
Board have any questions for Officer Gasson? Ma'am, do you have any questions for Officer Gasson? Would you like to go ahead and present your case then? You need to talk into the mic. That's okay.
Just keep moving it. When I get notices, please make sure I get it at 320 East Harrison, not 314 or anywhere. 314 with the notice was put in front of 314. I get the mail at 320, but I don't know, something. And then there's something about Boyer Street. That has to do with the property across the street at 333, not 320. So, because I saw that on something.
That might have been a typo. No.
See, that property, and we own that property across the street. That's 333. But my property is 320.
That just.
I have one box for 314 and 320. And
the Boyer thing was because of as I stated, the previous case, and there were some ownership issues.
Right.
So that's what Boyer was, because that was the previous listed address. So that's the reason why there was a Boyer Association.
Yeah, right.
Pinellas County Property Appraiser for 314.
They won't change it.
It has 2375 Northeast Coachman LLC as the listed owner. So there's some stuff you may need to take care of with the county to clarify that. That's the reason we have to send based on those addresses. So that's why they're like that.
Okay.
Anything else, ma'am?
Can I move the notice now, or the notices that's in front of 314?
Oh, you can take the sign down, yes, ma'am.
Okay.
Okay, does the board have any questions for Ms. Bauer or Ms. Williams? Officer Gasson?
I have nothing further.
Summary?
I think we're okay. Thank you.
Anything else you'd like to say, ma'am?
Did the best I could do.
Okay. So close the public portion of this case and entertain a motion.
Oh, and when do I pay the $91?
He'll tell you in a minute.
Okay.
I move that based on the testimony, evidence, facts presented by law, that the respondent was in violation of Section 8-52 of the Tarpon Springs City Code from the date of 10/9/2018 until the date of 10/22/2018, and a fine of $20 a day for 14 days, $280 total. In addition, I move that the city be awarded $91.50 for cost incurred prosecuting the case.
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes.
Okay, so Mrs. Williams, I'm just going to summarize. The city decided not to move forward on 133.02, 133.03, or 40.00. Those are all in compliance. The board, however, did find you in violation of City Code Section 8-52 for having been in violation from October the 9th through October the 22nd. The board has ordered a fine of $20 a day for those 14 days to be paid In addition to that, the city has been awarded its prosecution costs of $91.50. There will be an order. It will be entered within the next 10 days, and it will be mailed to you. I'm sure that as a courtesy, they'll send it to you at the address at 320 Harrison Street so that you get it directly. If you don't understand what happened today, feel free to call Code Enforcement Department tomorrow or any day thereafter, and they'll be able to explain to you what has happened. Thank you.
Thank you, ma'am. Okay, now we're on number 8.
Oh, I had 18 down.
Did I do it?
We already did 18?
Yeah.
Yeah, okay. I'm sorry. Okay. Did 17. Okay.
Okay, number 8. Case number 18-800000689.
Bye-bye.
At 438 Athens Street, Aaron Koulianis. Was here.
Nobody here. Thank you, Officer Steve Gasson, City of Tarpon Springs Police Department. Code Enforcement, case 18-800000689. The property address is 438 Athens Street. The listed property owner is Irene Koulianos. Exhibit number 1 going before the board are all of my photographs. Exhibit number 2 of my notices, including notice of violation and notice of hearing. Exhibit number 3, administrative documents to include the case summary, property appraiser and tax collector records, and any emails. Exhibit number 4 is the affidavit of posting and a copy of the sign. All the notices were mailed to the property owner of record, determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearings are sent via certified return receipt as well as first-class mail. And Madam Chairman, please accept these into the record as evidence.
Yes, Bobby, please accept those.
Yes, ma'am.
The case began on August 30th of this year. There was a large amount of trash dumped out front. There's trash and debris in the street. There's chickens and roosters on the property, and there's no permits on file. The business is no longer existing. The building appears vacant. Trash and debris were in the rear yard. There was an old carport kind of frame on the east side of it in a driveway that wasn't functional, and the metal was just piled up. On September 21st, a notice of violation was mailed, certified and return receipt, as well as first class. On October 11th, the pile of debris out front, the metal pipes on the side, and there was still debris and trash in the rear yard. Specifically in the rear yard, there was like a little shed, and it had some large piece of a plumbing fixture. I don't know if it was a bathtub, hot tub, shower enclosure, or something, but that was stacked up in the backyard. I was able to see the backyard because the person that lives 2 doors to the west also owns the property to the north of this. So he allowed me to go in the back, and I was able to see the violations from his property. As you guys are well aware, normally I see it from the right of way, but I was able to see a large number of things from the front, but this is the backyard. I was able to see the tall item was above the 6-foot fence, and I could clearly see it. So I conducted my final inspection today. As I stated, that plumbing fixture was still leaning up against the shed in the rear, and it wasn't in compliance. We got a phone call from the property owner, somehow contacted code enforcement, and they requested that we re-inspect again after they contacted the office because they believed they were in compliance. I went out this morning and I conducted a re-inspection, and the plumbing fixture I was talking about was gone, and primarily the backyard was in pretty decent shape. The problem is everything's stacked up curbside, which wouldn't be normally a huge issue if you had trash service, but their utilities have been cut off and there's a utility lien on the property. So that debris is not going to be picked up by Waste Management on today being a normal trash day for the city. So I confirmed that through city utilities that there is no active utility account. So it is trash and debris that won't be picked up by the garbage company. So what's before the board right now are violations of 8-22, the accumulation of trash, 8-40, the duty to maintain private property, the nuisance prohibitions that deal with 852, and I would like to establish them for the violation of City Code 4-3, which is having the animals in the residential district, just in case they decide to bring chickens back after this case is taken care of. And that's all I have at this time.
Board have any questions for Officer Gaston?
I have nothing further, ma'am.
We're ready for motion.
Move that based on, Move that based on the testimony, evidence, and facts presented by law that at the time of the alleged violation, sections 8-22, 8-40, and 8-52 of this Code of Ordinances of the City of Tarpon Springs was in force and effect, and respondent was in violation thereof.
Second.
Any discussion?
Yes, what, did 4-3, was that supposed to be added on?
That was what the city was asking, yes.
To add that
4-3 was originally when I went out, they had chickens. And sometimes people have a tendency to take them away until the case is done and then they bring them back. So I would like to establish them under 4-3 so in case in the next 5 years they decide to bring chickens back.
So
they're
it
established.
should be in our motion.
Sure.
Yes, I would believe so.
I'd like to add 4-3.
Do we have a second on that?
Second.
Any more discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes. Your recommendation? Time frame? Amount?
I would say 30 days, $25 a day.
Have a motion, please?
I move that respondent shall have until December the 8th to bring the property into compliance with Code 4-3, 8-22, 8-40, and 8-52, or suffer a fine of $25 a day thereafter the respondent remains in violation of said code.
Second.
Any discussion?
Do you need 4-3 in there?
I did.
I missed it. Thank
I'm
you.
sorry.
Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks.
Yes.
Mrs. Archer.
Yes. Okay, number 9. Case number 18-800000690 at 444 Athens Street, Corometis Living Trust, Savesti Corometis Trustee.
And Madam Chairman, after this case, if we can, we take a case out of order since she's here, and then
Sure.
then we won't have anybody else here. It's old business.
Okay.
It's a request for a rehearing. So after this one, if that's okay with you.
Be fine.
Okay, thanks. Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement, case number 18-800000690. Property address is 444 Athens Street. It's the Corometis Living Trust. Savesti Corometis is the trustee. Exhibit number 1 are my photographs to include inspections. Exhibit number 2, notices of hearing and notice of violations. Exhibit number 3, administrative docs, case summaries, property and tax collector records, and any emails. Exhibit number 4 is the affidavit of posting and a copy of the sign. All my notices were mailed to the property owner of record as determined by Pinellas County property appraiser and tax collector. All notice of violations and notice of hearings are sent certified return receipt as well as first class. And Madam Chairman, please accept these into the record as evidence.
Yes. Bobby, if you receive those, please.
Yes, ma'am.
444 Athens Street is directly west of 438 Athens Street. So while I was inspecting the one, I noticed the other. August 30th of this year, the lot was overgrown, primarily in the rear. There was a green Ford with no tags. There's a shed in the back that's falling over, and trash and debris on the property that needs to be cleaned up. On August 30th, the notice of violation was mailed first class and return receipt. On September 29th, I conducted a reinspection. The car had been removed, but there's still an old utility trailer. There's still trash and debris. And I advised at that time that if the property owner wants me to allow me on the property to inspect, I'm more than happy to do that. October 1st, the final notice of violation was mailed via first class. On October 17th, I conducted a reinspection, and the property was cleaned up somewhat. There was still some trash and debris remaining, and the fence in the rear, which was originally cited, still needed to be repaired, and the old shed hadn't been removed. I believe you guys can probably see in the picture. I'm not necessarily a building engineer, but I'm pretty confident that that shed is leaning at an angle that the only reason it's still in the state that it's in is I think there's a fence under it on the east side of it. which also encroaches onto the neighboring yard of 438 Athens, which isn't allowed anyway. So that shed's in pretty bad shape. And then there was some other items next to the shed that need to be disposed of, shelving unit and so on and so forth. Again, this property, the neighbor now one door to the west had allowed me in his property to the north, which I could clearly see the backyard because it's only like a 4-foot chain link fence. So those photographs were taken from the neighbor's property with his consent. On October 17th, the notice of hearing was mailed first class, return receipt. October 29th, I posted the property. I conducted a reinspection yesterday. The only violations that remain is the fence still needs to be repaired and the shed is still there. There's still some trash and debris in the rear yard. We did get back the notice of violation and notice of hearing returned to our office signed, and we have had contact with the owner via phone calls. What's before the board at this time is 8-22, accumulation of trash. 8-40, the duty to maintain private property. Part of that code also includes having a dilapidated structure, which the shed I think would fairly qualify as a dilapidated structure. And 852, the nuisance prohibitions dealing with cleaning up debris and maintaining your lot. Also, I cited them under 6-1, the 2017 Florida Building Code and the 2018 version of the International Property Maintenance Code. The International Property Maintenance Code also addresses under 3.302.7 accessory structures, which the shed would be considered. It also kind of encompasses the fence as well, that it has to be maintained in good, safe order. And then I also cited them under our specific city code of 36.03 for fences, walls, and hedges. As you can see in the photograph, the chain link fence, the top rail is bent and it's in poor condition. And that's all I have at this time.
Does anyone else have any questions for Officer Gaston? Anything to summarize?
No, thank you.
So close the public portion of this and entertain a motion.
I move based on the testimony, evidence, and facts presented by law that at the time the alleged violation, sections 8-22, 8-40, 8-52, 6-1, 36.03, and IPMC 302.7 of the Code of Ordinances of the City of Tarpon Springs was in force and effect, and the respondent was in violation thereof.
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks.
Yes.
Mrs. Archer.
Yes. Recommendation for time frame or daily fine?
Yeah, there's, since 2013, so 5 years, there's been 6 prior cases, all kind of related to duty to maintain private property and accumulation of trash. So it seems to be an ongoing kind of theme with the property. I'd ask the board to consider 30 days and $100 a day.
A motion?
I move that the respondent shall have until December the 8th to bring the property into compliance with section codes 8-22, 8-40, 8-52, 6-1, 36.03, and IPMC 302.7, or suffer a fine of $100 a day thereafter the respondent remains in violation of this code.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes. Okay, Beth, which one did you want to go with?
It's case number 18-8000479, 650 East Tarpon Avenue.
Do you have a number on that?
38.
Thank you.
Very last one.
Can I submit this?
I didn't swear her in.
You can show it to the city. Okay, so this is a petition to reconsider or rehear, and let me just read that rule to you because you don't do this that often. So this is Rule 5, Section 3, that's been in existence since 1989. Any aggrieved party may petition the board to reconsider or rehear any board order resulting from public hearing. This petition must be made in writing and filed with the board secretary no later than 30 days after the execution of the order and prior to the filing of any appeal. Upon receipt of the petition, the board will consider whether or not to reconsider or rehear the case. A motion to approve a petition to reconsider or rehear must be made by a board member who has previously voted on the prevailing side. A motion to approve a petition to reconsider or rehear a case must set the date and time for the rehearing. The rehearing may be held at the time of the consideration of the petition if the petitioner and all other parties agree. The board will not hear oral argument or evidence in determining whether to grant the petition to reconsider or rehear. So, in layman's terms, you need to decide whether or not you want to rehear this case. If you don't want to rehear the case, it would be a motion to deny. If you want to rehear the case, then we need to determine when that case is going to be reheard.
I make a motion to rehear the case.
Second.
I have no objection to that.
We have something in writing, I can't.
That's not it.
No, it's 4.
It's coming.
Oh, okay. You have made a motion?
Seems to have died.
Do we have a second on that motion?
Yes, there was a second.
There
Did
any-
not die.
Any discussion?
Yes. Are there still people living there?
Hold on a second. There's no oral argument or evidence to be determined, so you have to make your decision based solely upon this written petition.
Any other discussion? Roll call.
Ms. Norfleet,
Yes.
Mr. Robinson,
No.
Mr. Kramer,
No.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes.
Okay, so you've granted the motion to rehear the case, and then you need to decide whether you're going to hear it today or the date you're going to hear it. Are you prepared to move forward today?
Not today.
Can I say something? Yes.
I'm sorry?
Say something?
No, I want you to answer my question first.
Yes.
Okay. Is the city ready to move forward today?
No, we're not.
Okay, so you need to set it for some time in the future because both parties can't agree, and so you may want to just set it for the next meeting in December.
If I can just add for that, I was intending on having a very, very small December docket and only hear affidavits of compliance and non-compliance, if, for whatever it's worth.
You want to do it in January then?
I'm perfectly okay with
Is that
January.
okay with you to do it in January?
I don't understand anything.
Okay, there's going to be a rehearing.
You wanted to rehear the case.
No.
Well,
That's what it is.
I think I don't make myself clear. I don't want you guys to rehear the case because I'm fixing what needs to be done. I just needed an extension.
okay, can I see that? I didn't see it.
So I guess I didn't.
Was this it?
There was something else that went by.
Yeah, an email.
By November.
The other one was from a construction company.
Oh.
Okay, this says 650, okay, that's it, okay.
I guess there might be two parts of that first sentence.
Okay, was there a request for a rehearing then? Was there a second page?
As this email, as it states, may I please have my case reheard? That's what we went based on.
Okay. Okay. All right, so the board has determined to rehear the case? Okay, so the question is, are you going to be prepared in January?
Sir,
It's a yes or a no answer. Yes or no?
Yes.
Okay, are you going to be ready in January?
Yes, sir, we will be.
Okay, so maybe there would be a motion then to rehear the case at the January meeting, which is, what day is it, Bobby, is January hearing? Okay.
Have a motion?
Make a motion that we rehear the case in January the 10th meeting.
Need a second?
Second.
Ms. Norfleet?
Any discussion? Roll call?
Ms. Norfleet,
Yes?
Mr. Robinson,
No.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes.
Okay, so this is your notice right now. You may get an additional one in the mail. You need to be prepared to hear your case here at 2 o'clock on January the 10th. Okay? All right. Okay, we're done, ma'am.
Number 10?
Clarification on top of that?
Case number 18-800000695 at 41918 US Highway 19 North, B.K. Alisandradas, trustee.
Thank you, Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. Case 18-800000695, property address 41918 US Highway 19. This is right on the corner of Live Oak and US 19, be the southwest corner, a little bit north of Hydrologic. It's a storage lot. Property owner is BK Allison Dorados Trust. Exhibit number 1 before the board are photographs. Exhibit number 2, notices, including notice of violation, notice of hearing. Exhibit number 3, administrative documents to include case summary, property appraiser, and tax collector records, and any emails. Affidavit of posting and a copy of the sign is exhibit number 4. All the notices were mailed to the property owner of record as determined by the Pinellas County property appraiser and tax collector. All notice of violation and notice of hearings are sent via certified return receipt as well as first class. And Madam Chairman, please accept these into the evidence
Yes,
record.
Bob, if you receive those, please.
Yes, ma'am.
This case started on August 30th of this year. The trees are overgrowing the sidewalk. I believe we got the complaint from the City Streets and Sidewalks Division. There's numerous Brazilian pepper trees on the property. There is a certificate of occupancy issued for the property. And there's vines growing into the trees and fencing causing damage. August 30th, the notice of violation was mailed certified as well as first class. On September 26th, I conducted a reinspection and there was no change. We also sent a final notice of violation certified in first class on September 26th. On October 19th, I conducted another reinspection. There was no change, and now the trees have continued to grow and completely block the sidewalk. On October 19th, the notice of hearing was mailed certified as well as first class, and I posted the property on October 29th. November 7th, I conducted the final inspection, and there was no change to the property. All the mail was return attempted but not known, so we've got no correspondence from the owner whatsoever. So what's before the board for consideration is violation of City Codes 8-40, duty to maintain private property, 8-52, the nuisance prohibitions, which specifically deal with maintaining your lot and your grass, 13302, applicability and maintenance of trees, vines, and noxious plants, 13303 are the tree exemptions, and what that basically states is if you have a certificate of occupancy, you have to assure that no Brazilian pepper trees are on your property. And then 8-22 is the accumulation of trash. As I stated, there is some trash strewn about the property and on the right-of-way. The pictures significantly depict the one picture that really shows the overgrowth is Live Oak is the street on your left, US 19 is in front of you, so this would be the north side of that property. And as you can see, the sidewalk's completely obstructed. And it does continue all the way through to US 19. And at this point, I have nothing further.
Board have any questions? Can you summarize? Officer Gaston?
I have no summary, thank you.
Close this portion and entertain a motion.
I move based on the testimony, evidence, and facts presented by law that at the time the alleged violation, sections 8-22, 8-40, 8-52, 133.02, 133.03 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Second.
Any discussion? Roll call.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes. Recommendation for time frame or daily fine?
As I stated, we started this back in August, so I would say 30 days and $100 a day to motivate them. We've had no priors at that. Looking at the wrong one. We have had a couple of priors, but they were unrelated to this, so I would still stick with the 30 days and $100 a day. I kind of want to get that sidewalk cleared off as soon as possible.
Motion?
I move that the respondent shall have until December the 8th to bring the property into compliance with section codes 8-22, 8-40, 8-52, 133.02, and 133.03 of the city codes, or suffer a fine of $100 a day for each day thereafter the respondent remains in violation of said code.
Second.
Any discussion? Roll call.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes.
We're just gonna record you and then fill in.
Case number 18-800000701, vacant lot west of 757 Bay Shore. 112715, what?
You don't need to read all that. That's the parcel identification number.
Okay, Parley LLC.
Thank you. Case number 18-800000701. As you stated, the vacant lot west of 757 Bay Shore. The parcel identifier is 1127-15-04878 002-0130. Property is owned by Parley LLC. Exhibit number 1 before the board are photographs. Exhibit number 2, notices of violation and notice of hearing. Exhibit number 3, administrative docs, property appraiser and tax collector records and emails. Exhibit number 4 is the affidavit of posting and a copy of the sign. All my notices are mailed to the property owner of record based on Pinellas County property appraiser and tax collector databases. All notice of violations and notice of hearings are sent certified return receipt as well as first class. And Madam Chairman, please accept these into the record as evidence.
Yes, Bobby, please.
Yes, ma'am.
On August 30th of this year, I got numerous complaints about Bayshore Drive being overgrown. There's a number of different parcels on there. The first photograph going before the board just kind of shows you where the parcel is. It's a parcel, measurement-wise, I came up using the largest side, which was 99 feet by 100, puts it at 99 square feet, or 9,900 square feet, which according to our city code requires that the lot be completely cleared and maintained that way. It's vacant and it's overgrown, as you can see in the photographs. August 31st, I mailed a notice of violation certified in first class. September 26th, conducted a reinspection and there was no change. We gave them some more time, sent out a final notice of violation on September 28th. I reinspected on October 18th, still not been maintained as required. On October 19th, the notice of hearing was mailed, certified as well as first class. On October 29th, I posted the property and signed the affidavit for posting. Conducted a reinspection yesterday. There was no change. We had none of the mail returned. We have had phone calls in the office from Mr. Pallardy. As a matter of fact, I think it was yesterday or the day before, he stated that he had been red tagged on November 6th. He was red tagged while cutting the property, and that's why it's not in compliance. We asked him to provide who red tagged him, which would have been basically a stop work order. He never produced any of that information. He actually, I don't think, ever even got back to us at all. When I drove by, it didn't appear that anything had started to be done to it at all. And he's unfortunately not here to try to explain that. So basically what's before the board at this time is a violation of City Code 8-40 and 8-52, the nuisance prohibitions that deal with maintaining your private lot. And that's all I have at this time, ma'am.
Any questions for Officer Gaston?
Take clear cut.
Because it's under 10,000 square feet, our city code that requires that it, all undergrowth and whatnot needs to be, that property needs to be maintained. If he's got established trees, those aren't affected. I believe if they're over 6 inches in diameter. But otherwise, all the undergrowth, noxious invasive species, and all that stuff need to be cleared, and that property needs to be maintained.
Any other questions? Entertain a motion?
I move based on testimony, evidence, facts presented by law that at the time of the alleged violation, sections 8-40 and 8-52 of the Code of Ordinances of the City of Tarpon Springs was in force and effect, the respondent was in violation thereof.
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes. Time frame or daily fine?
Well, he said he was out there starting it, so I think 30 days and $100 a day would probably take care of that.
Motion?
I move the respondent shall have until December the 8th, 2018 to bring the property into compliance with section codes 8-40 and 8-52 or suffer a fine of $25 a day or each day thereafter the respondent remains in violation of said code.
Second.
You didn't want to make that 100?
So will we go for it?
Any other? Okay.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes. Case number 18-80000706 at 224 East Tarpon Avenue, Lundakis Properties, Inc.
Thank you. 18-80000206, 224 East Tarpon Avenue. It's Johnny's Restaurant, for those of you to be familiar with it. Lindiakos Properties Incorporated. Exhibit number 1 are photographs. Exhibit number 2, my notices, notice of violation, notice of hearing. Exhibit number 3, administrative docs, case summary, property appraiser, and tax collector records and emails. Affidavit of posting and a copy of the sign is exhibit number 4. All the notices were mailed to property owner of record based on the Pinellas County property appraiser and tax collector databases. And all notice of violations and notice of hearings are sent certified mail as well as return receipt requested. And Madam Chairman, please accept these into the record as evidence.
Yes, ma'am.
A complaint came via the city on September 4th about flag signs out front, a large banner on the building advertising brunch, small structure sign erected in front of the existing sign, banner on the east side of the building stating parking. These are all violations of city sign codes. I then had some, we sent out a notice of violation on September 4th. I re-inspected on October 31st, and it was postponed from October 10th for planning and zoning because they did come in and start the process of dealing with planning and zoning regarding getting permits, what they're allowed, what they're not allowed, so on and so forth. So that's why I conducted the re-inspection on October 31st. On October 23rd, the notice of hearing was mailed, and on October 29th, I posted the property. I conducted an inspection yesterday. Actually, I was working another detail, and as I was driving home on the 6th, he had his Taco Tuesday sign out, so that's kind of the little blurry cell phone picture that's at the end, which I confiscated one of his previous flag signs, which is in the office, that was out, and he was specifically told not to post it. I would take it if he put it out again. And then I was unable to grab the Taco Tuesday sign, but I took a picture of it. Basically, nothing has changed. I did talk to Johnny, who's the tenant, earlier. He left. He had to go to the airport. He is in the process. He did file his permit. He finished the application process today. So he basically just needs some time to try to get in compliance. At this point in time, he's still in violation of the city codes, which is City Code 179.00, which is requiring permits for your signs. City Code 181.00, which are signs specifically prohibited. Things like banners, things like the feather signs, they're specifically prohibited in our city code. So that's that violation. And there's certain signs that need to be removed. Those are the banners, which is City Code 184.00. And also that additional little structure that was put up out front advertising his business. So those are the 3 violations before the board at this time. As I stated, he's not in compliance, and he is in the process of working on it through the city. And I have nothing further, ma'am.
Board have any questions?
I do.
Yes.
The landlord is the one that's responsible for this, though, not the tenant. Is that correct?
Well, he is the tenant. It is his business, and he was also mailed. We mail the notices of violations and everything to the property owner, and we also, if we know there's a tenancy, we will send to the tenants as well. It's his business. He's the one, they're his signs. But ultimately, yes, it is the property owner that is subject to any sanctions, if you will.
Okay. Motion?
Sure. I move that based on the testimony, evidence, and facts presented by law, that at the time the alleged violation, sections 179.01, section 181.00, 184.00 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes. Time frame, daily time?
When we talked before he left, he had asked for 60 days, and then motivating between him and Mr. Lindiaco. So I'll go with my $100 a day again.
Motion?
I move that the respondent shall have until January the 7th to bring the property into compliance with section codes 179.01, 181.00, 184.00, or suffer a fine of $100 per day for each day thereafter the respondent remains in violation of said codes.
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes. Case number 18-800000722 at 423 East Harrison Street, Alicia Miller.
Thank you. Case number 18-8000722, 423 East Harrison Street, Alicia Miller. Exhibit number 1, inspection photographs. Exhibit number 2, before the board, are notice of violations and notice of hearings. Exhibit number 3, administrative docs, property appraiser, tax collector records. Exhibit number 4, affidavit of posting and a copy of the sign. All the notices were mailed to the property owner of record determined by the Pinellas County property appraiser and tax collector. All notice of violations and notice of hearing are sent certified return receipt as well as first class. And please accept these into the record as evidence, Madam Chairman.
Yes, ma'am.
September 6th of this year, conducted the initial inspection. The complaint was regarding a vehicle that's inoperative or had expired tags. When I conducted the inspection, there's a black Ford in the driveway, Florida tag Henry Frank Henry, David 91. The tags expired in 2017. At that time, we sent a courtesy letter mailed first class. I conducted a re-inspection on September 22nd. The vehicle is still there. On September 24th, a notice of violation was mailed. And on October 10th, conducted another re-inspection. The vehicle's still there, still had expired tags. Notice of hearing was sent on October 11th. I posted the property on October 29th. On November 7th, the property was still there. She had some debris in the rear yard, which has since been taken care of, so that's no longer for consideration. Beth's had numerous phone conversations with the property owner, and she was here earlier. And she's waiting on somebody to pick the car up, and she was hoping it would have been done by now, but she again just needed a little bit of time. So as of right now, the only thing that's before the board I'd like them to consider is the 40.00, which is the parking and storage of abandoned vehicles, because the Ford is still there. 840 and 852, I'd like to not have considered by this board because they do appear to be in compliance. And that's all I have at this time, ma'am.
Any questions from the board? Motion?
I move that based on the testimony, evidence, and facts presented by law that the alleged violation 40-40.00 of the Code of Ordinances, the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Second.
Discussion? Roll call.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes. Time frame? Daily?
She said she would just ask for December 1st, the beginning of the month.
December 1st?
December 1st. She said she should have it out in a couple of days, so she just asked for a couple of weeks. Actually, I offered her a couple of weeks, and she said that'd be great.
And,
Fine, $25 a day. She got no priors.
motion?
I move that the respondent shall have until December the 1st to bring the property into compliance for Code Section 40.00 or suffer a fine of $20 a day. For thereafter, the respondent remains in violation.
Second.
Any discussion? Roll call.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes. Case number 18-800000730 at 1415 Oleander Drive, Helen, Panetta, State.
Thank you. Case number 18-8000370, 1450 in Oleander Drive, as you stated, Helen Panetta's estate. The property changed some ownership previously, and it was also related to some other cases that we've had. Exhibit number 1 before the board are the photographs of my inspection, my initial inspection. My notices are exhibit number 2. Exhibit number 3 is the case summary, property appraiser, and tax collector records. Exhibit number 4 is the affidavit of posting and a copy of the sign. All my notices are mailed to the property owner of record as determined by the Pinellas County property appraiser and tax collector. Notice violations and notice of hearing are sent both first class as well as return receipt requested. And Madam Chairman, if you would please accept these into the record as evidence.
Bobby, please receive them.
Yes, ma'am.
September 11th of this year was my initial inspection. It was called in by a neighbor complaint. The property's not being maintained. There's a fence along the west side, and the fence is installed backwards. City code requires, I call it the ugly side, but it's the stringers. The stringers are required to be facing inward towards your property, not towards your neighbor's property. Also, as you can see in the photographs, the fence is having some issues with falling over. There's vines growing on it, which are actually causing it some additional issues. The pool's not being maintained, the filter's not functioning, and the reason why I know that is I did make contact with the tenant, and she did allow me into the property, and all these photographs were taken after she let me into the property. It's not, as I stated, it's not being maintained, and the filter's not functioning. The cover on the pool is holding water, and it's not providing any necessary safety or security. There's Brazilian pepper trees on the west side of the driveway, and the screen was broken on one of the windows on the east side of the house. On September 14th, mailed the notice of violation, return receipt, as well as certified. On October 23rd, I conducted a reinspection. Admittedly, I haven't been able to get a hold of the tenant again to get in the backyard, so I really can't tell you if anything has changed, but I also have had no contact with the owner wanting to meet me there and let me into the backyard. So to the best of my knowledge, everything that was occurring in the backyard is still in violation. And so on October 23rd, I conducted the reinspection. There was no change. And at that point in time, we opted to send it to Code Board. So October 23rd, the notice of hearing was mailed. October 29th, I posted the property. On November 7th, I did conduct a reinspection. At that time, the Brazilian pepper tree had been trimmed, but it was still there, and the code requires that it's removed, and it's not allowed to regrow ever. And then as I probably skipped over in the very beginning, there was a Ford in the driveway with expired tags to add to this. That Ford with expired tags still remained in the driveway on November 7th, and we confirmed the tags through DHSMV being expired for that vehicle. So we had a notice of violation returned to us, attempted but not known, which basically means they tried to serve it, but they had zero success, and we've had no contact with the owner whatsoever or anybody representing the estate or whatnot. There must be somebody because she rents it. She says that has a landlord. She's not related to the property owner. She moved in a little while back because I had a previous case there, and I had talked to a family member of Helen Panetta. So, so what's before the board at this time? 8-40, duty to maintain private property. 8-52, the nuisance prohibitions, maintaining your yard, so on and so forth. 6-1 of the city code, which adopts the 2018 IPMC and the 2017 building code. Under IPMC 303.1 is swimming pools and spas, etc., have to be maintained in a hygienic condition. Basically, the filters have to work, and you have to be able to see to the bottom of the pool. IPMC 304.14 requires that during certain times of the year, we're past it now, but at the time of the violation, between May and October, if you have a functioning window, you're required to have functioning screens on the window, according to IPMC, which the city code adopted. At that time, they did not. I guess technically we could say that since we're after October 1st, they're not in. They would be in compliance because they're not required to have functioning screens now. The tree exemptions, 133.03 requires that anybody with a certificate of occupancy has no Brazilian pepper trees on their property. 133.03 deals with the vines, as I discussed, when they start causing damage to fences and associated properties, they're becoming an issue. 36.03 fences, walls, and hedges. As I stated, the fence was installed properly and it's falling over, so it needs to be maintained, removed, or replaced. And 40.00 deals with the vehicle with expired tags. And that's all I have at this time, Madam Chair.
Anyone have any questions? Call for a motion?
Move that based on the testimony, evidence, and facts presented by law, that at the time the alleged violation, sections 8-40, 8-52, 6-1, IPMC 303.1, IPMC 304.14, City Code 133.02, 133.03, 36.03, and 40.00 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Second.
Any discussion? Roll call.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes. Time frame or daily fine?
Sorry.
Getting late.
I would say 30 days, and then I'll leave the fine up to the board.
Okay.
I move that the respondent shall have until December the 8th to bring the property into compliance with code sections 8-40, 8-52, 6-1, IPMC 303.1, IPMC 304.14, City Code 133.02, 133.03, 36.03, 40.00, or suffer a fine of $100 a day for each day thereafter the respondent remains in violation of said code.
Any discussion? Roll call.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes. We're on 16. Case number 18-800000838 at 608 Royal Drive, Tina Hinton.
Thank you. Case number 18-800000838, 608 Royal Drive. Property owner is Tina Hinton. I'm going to put the property in compliance for the violation of the city code. So I'd like to just move forward with establishing the property for the violations that I'm going to discuss. So exhibit number 1 are my photographs. Exhibit number 2 are the notices of violation and notice of hearing. Administrative documents, case summary, and property appraiser and tax collector records are exhibit number 3. Exhibit number 4 is the affidavit of posting and a copy of the sign. All the notices were mailed to property owner record based on the Pinellas County property appraiser and tax collector databases. All notice of violations and notice of hearing are sent via certified as well as first-class mail. And Madam Chairman, please accept the exhibits into the record as evidence.
Bobby, please accept those.
Yes, ma'am.
On October 18th is the date of the initial inspection. I was inspecting with the city problem with the stormwater. It was actually related to her property, but over on the Chesapeake side of the property. While I was speaking to Tina in the street, approximately 8 ducks and 4 chickens came trotting out of the property, walking across the road into her property. I asked her if she had a permit or anything like that, and she did not. Ducks are not permitted to be kept in the city at all, and chickens you can have 4 as long as you have a permit and you have a coop. These were roaming freely, and she kind of became a little bit uncooperative. So on October 23rd, I mailed her a notice of violation and a notice of hearing. On October 29th, I posted the property. I conducted the inspection yesterday. I put her in compliance because I did not see the chickens or the ducks, but there is a fenced-in area that I can't see through. She does have coops in there. She was in here earlier and stated that she got a permit for the coops, but I didn't cite her for that. So it was strictly what I cited her for is City Code 4-3 doesn't allow you to have farm animals when you have residential property in the city. And as I stated earlier, you can have 4 chickens, no roosters, but you have to have a coop and a city permit, and you cannot have ducks. So the best thing I can say at this point in time is she's in compliance because I did not see the ducks or the chickens, but I would like to establish her because in case the ducks and chickens show back up. And that's all I have at this point in time.
Any questions for Officer Gass? Motion?
I move that based on testimony, evidence presented by the law, that at the time of the alleged violation, section 4-3 of the Code of Ordinances of the City of Tarpon Springs was in full effect, and at the time of the notice of violation, the respondents were in violation of said code sections. However, they are now in compliance.
Second.
Any discussion? Roll call.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes.
No, you're done with that one.
Established. Okay, 19. This is a repeat violator in violation from 10/10/18 till 10/14/18, 5 days. Case number 18-800000826, 316 Bay Street, down at Fatalitas.
Thank you. As you stated, it's a repeat violator case from October 10th to October 14th for a total of 5 days. The previous repeat violator case that established it was 18-800000623, specifically for violation of City Code 42.00. At that point in time, this board assessed a $50 per day fine for that violation. Case before the board now is 18-800000826. The property address is 316 Bay Street. Donna Fatalitas is the listed owner. Exhibit number 1 are my photographs. Exhibit number 2, the notice of violation and notice of hearing. Exhibit number 3 are the case summary, property appraiser, tax collector records, and any emails. Exhibit number 4 is the affidavit of posting and a copy of the sign. And exhibit number 5 is the affidavit of prosecution costs. All my notices are mailed to the property owner of record determined by Pinellas County property appraiser and tax collector databases. All notice of violations and notice of hearings are sent return receipt as well as first class. And Madam Chairman, please accept these into the record as evidence.
Bobby, please accept.
Yes, ma'am.
The initial inspection was on October 10th. I was actually conducting an inspection on the neighboring property, and I noticed that there was a boat on a trailer parked in the right-of-way out front. He'd been previously cited for the same violation a couple of times. And on October 11th, the repeat violator notice of hearing was mailed. On October 29th, I posted the property. He contacted our office in the meantime, and I put him in compliance on October 14th, so that's a total of 5 days. and it's a violation of City Code 42.00 for having the boat on the property as he was previously cited. And I have nothing further.
Any questions for Officer Gasson?
I move that based on the testimony, evidence, facts presented at law, that the respondent was in violation of City Code 42.00 from 10/10/18 until 10/14/18.
Second.
Wait,
Yeah. We need to establish the dollar amount of the fine.
till such time the property is brought to compliance, a fine of $25 a day, $50 a day, per day shall be imposed until compliance is met. In addition, the city is awarded $69.50 for costs it incurred in prosecuting the case.
You did say 50, correct?
$50 a day.
Second.
Okay, they're in compliance, we just gotta
They're
$50
not.
for
Are they in compliance?
Yes, they are. It was
Oh my
for
gosh.
5 days.
50 times 5,
Sorry.
5 days.
Yeah,
Go ahead.
$250.
Yeah, that's fine. So I just want to make sure that everybody understands the motion. The motion has been that find him in violation from October the 10th to October 14th, a total of 5 days at $50 a day for a total of $250, and also awarding prosecution costs of $69.50. That was the motion.
That is the motion.
There's a second.
I'll second.
Any discussion? Roll call.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes. Number 20, repeat violator in violation from 10/16/2018, 1 day. Case number 18-800000835, vacant lot on Cedar, Stanley and Demetrius Tavoris.
Thank you. This is a repeat violator case. It was for a period of 1 day. The case that it was established under was 17-800000468. It was a repeat violator another time under 18-8000424 earlier this year. And the case before the board is 18-800000835. It's a vacant lot on Cedar Street. Stanley and Demetrios Kavouris are the property owners listed. Just for the board, there's been numerous priors on this property, all the way back to 2000, but within the last 5 years, for this violation, easily about 6 or 7 in the last 5 years. I've already had 2 this year, 1 last year. All the photographs going before the board of my inspections are exhibit number 1. Notice violation, notice of hearing are exhibit number 2. Exhibit number 3, administrative docs, case summary, property appraiser, and tax collector records, and emails. Exhibit number 4 is the affidavit of posting and a copy of the sign. Exhibit number 5 is the affidavit of prosecution costs. All my notices were mailed to property owner of record, determined by the Pinellas County property appraiser and tax collector. Notice of violations and notice of hearing are sent certified return receipt as well as first class. And Madam Chairman, please accept these into the record as evidence.
Cash bog, please accept.
So as I stated, on October 16th, the property was overgrown. Beth's in possession of his email address, so contacted him, and he was able to rather quickly get somebody down here to take care of the property. He was previously, as I stated, established by the board in 2017. The last case that was before this board, I don't have the period of time, but he was fined $150 a day. And that was earlier this year for the same violations. So moving forward, on October 16th, the repeat violator notice of hearing was mailed, first class and return receipt. October 29th, we posted the property. And as I stated, we had email contact with the owner. None of the mail had yet been returned. So for that 1 day, the property was in violation of 840 and 852. And that's all I have before the board at this time.
Any questions for Officer Gasson? Any motion?
I move that based on the testimony, evidence, facts presented by law, that the respondent was in violation of sections 8-40 and 8-52. From 10/16/18 until 10/16/18. Fine of $150 per day for 1 day, a fine of $150 total. In addition, I move that the city be awarded $76.50 for the cost incurred in prosecuting this case.
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes. The repeat violator in violation from 10/18/18 to 10/28/18, 11 days. 18-800000844 at 3 Venetian Court. Mike Cazamirez and Micah Cazamira.
Thank you. As you stated, it's a repeat violator from October 18th to October 28th for a total of 11 days. The case that established this property was 17-800000401 for violation of 8-40 and 8-52, which are the same codes that are before this board. This is case number 18-800000844. It has a property address of 3 Venetian Court, although it's a vacant lot right at the corner of Venetian and North Spring. It's across the street from the yacht club. Property owners Mika Kazmarez and Kazmira. Exhibit number 1 are my photographs. Exhibit number 2 are my notice of violation and notice of hearing. Exhibit number 3, administrative docs, case summary, property appraiser, and tax collector records. Exhibit number 4 is the affidavit of posting and a copy of the sign. And exhibit number 5 is the affidavit of prosecution costs. All the notices are mailed to the property owner of record as determined by the Pinellas County property appraiser and tax collector. All notice of violation and notice of hearings are sent return receipt in first class mail. And please accept these into the record as evidence. Received a neighbor complaint on October 18th about the property being overgrown and trees not being maintained as required. The trees are not providing 14 feet of clearance above the roadway, and they're also not providing 10 feet of clearance above the sidewalk as the city code requires. Repeat violator notice of hearing was mailed on October 19th, first class, as well as return receipt. October 29th, I posted the property and signed the affidavit of posting. The repeat violator notice of hearing was returned to our office signed. We've had no contact with the owner, and it was back in compliance on October 28th for a total of 11 days in violation of 8-40 and 8-52. And I have nothing further.
Any questions for Officer Gasson? Go for motion.
I move that based on the testimony, evidence, facts presented by law, that the respondent was in violation of sections 8-40 and 8-52 of the Tarpon Springs City Code from 10/18/2018 until 10/28/2018. A fine of $50 a day for 11 days, or a total fine of $550. In addition, I move that the city be awarded $84 for the cost incurred in prosecuting this case.
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Weeks,
Yes.
Mrs. Archer.
Yes. Now we have affidavits of noncompliance. Case number 17-800000781 at 455 East Tarpon Avenue, 455 East Tarpon Avenue, LLC.
I move we accept the affidavit of noncompliance in that case and award the city the prosecution costs of $182.50.
Second.
Any discussion?
Voice vote, yes. All in favor?
All in favor?
Aye.
Aye. All opposed? Case number 18-800000371 313 Spring Boulevard, South, John Barron, C.O. Barry J. Barron.
I move we accept the affidavit of noncompliance in that case and award the city $167.50 in prosecution costs.
Second.
All accept?
Aye.
Aye.
That was sad. That was really sad.
Wrong anyway.
All in favor?
All in favor, how about that?
Aye.
Aye.
Opposed?
Okay.
Case number 18-800000373 at 722 Merlin's Court, James Bauer.
I move we accept the affidavit of noncompliance in that case and award the city $143.50 in prosecution costs.
Second.
Second?
Mrs.
I
Buckley?
second. Sorry.
All in favor?
Aye.
Opposed? Case number 18-8000559 at 423 South Piston Avenue, Reginald Wood.
I move we accept the affidavit of noncompliance in that case and award the city $142 in prosecution costs.
Second.
All in favor?
Aye.
Opposed? Now we have affidavits of compliance. All those. Oh. Do you want to do those?
We got money on each one of them, so
Oh, we
There's a
do.
couple at the
Oh,
end.
okay.
might as well do them.
18-800000762 at 1725 Sunkist Drive, Hera Family RE Trust.
I move we accept the affidavit of compliance in that case and award the city $76.50 in prosecution costs.
Second.
All in favor?
Aye.
Aye.
18-800000269 at 601 East Martin Luther King Jr. Drive, Deanna Ruth Gorman. Gorham.
I move we accept the affidavit of compliance in that case and award the city $127.50 in prosecution costs.
Need a second?
Second.
All in favor?
Aye.
Opposed? Case 18-800000292 at 727 Chesapeake Drive, Tina Hinton.
I move we accept the affidavit of compliance in that case and award the city $185.50 in prosecution costs.
Yeah.
No,
Hundred
no.
One
You're-
twenty.
We're
One
on
above it.
28.
Above it.
It's number 28.
28.
The one above it.
Tina.
Just did that.
You had requested affidavit, prosecution costs of $185.50. The prosecution costs in the affidavit are $120.
I
That's what they're bringing to your
understand, but I thought I
attention.
already did that. I'm sorry. Let me
No.
repeat, please. In case 18800000292, I move we accept the affidavit of compliance in that case and award the city $120 in prosecution costs.
I second.
All in favor?
Aye.
Opposed? 18-800000321 at 505 Mirrors Boulevard, Demetrius and Anastasia Kapitanopoulos.
I move we accept the affidavit of compliance in that case and award the city $185.50 in prosecution costs.
I second.
All in favor?
Aye.
Opposed? Case 18-800000339 at 512 Island Drive, S&N Tarpon Enterprises, Inc.
I move we accept the affidavit of compliance in that case and accept and award the city $156.50 in prosecution costs.
I second.
All in favor?
Aye.
Opposed? Case 18-800000340 at 514 Island Drive, S&N Tarpon Enterprises, Inc.
I move we accept the affidavit of compliance in that case number and award the city $156.50 in prosecution costs.
I second.
All in favor?
Aye.
Opposed? Do all these? Here, can I read them all?
You can just make his motion. Mr. Kramer's pretty good at making the motion.
Kramer.
The motion for 32, 33, 34, 35, all at one time.
Yeah, I can do those. Thank you. I move we accept the affidavits of compliance in case number 14-800000166 and in case 18-800000335 and in case number 18-800000527 and in case number 18-800000703.
I second.
All in favor?
Aye.
Aye.
Opposed? And we've got a fine reduction request, 37. Case number 17-8000435 at 724 North Avenue, Rebecca Ford, original owner. Read it over, right? Everyone look at it?
And here's the original. So it needs to go down. Yeah.
Anybody ready to make a motion?
Yeah, I got it. You. Want a motion on that?
Yes, sir.
I make a motion in case number 17800000435 that we do not accept a fine reduction.
I second.
Any discussion? Roll call?
Norfleet,
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes. Done that one. Okay. We have approval of minutes.
I make a motion that we approve the minutes of October.
September 13th?
September, I'm sorry, September.
Second?
Got 5 or 6 more cases. We're way ahead of time.
Okay, so there's
All
been
in-
a second.
All in favor?
Aye.
Aye.
Opposed?
Okay.
Alrighty. Do you have any public comments? Mr.
Yes.
Sheedy?
I have public comments. On your summaries that you guys got, you'll notice over on the side on the red, we added, trying to give you guys a little bit of information, and it's only with the repeat violators that deals with when they were established and then what their fine was previously, because we kind of wanted to give you the information, since the motions for repeat violators aren't handled the same way as a new case, where I get an opportunity to, the city's position on a time frame or a fine. We felt it was best that you had an understanding of what their previous fines established by this board were, so that you could make those decisions moving forward with their fine. So that's the reason why those are on here. We just started doing that this month. If you guys don't like it, we can take it off. Otherwise, we'll just leave it on there, just trying to give you more information. The other thing I briefly want to talk to you guys about is I finally got the opportunity to kind of do my first real abatement where we cleared a lot. We got rid of a mobile home, if you guys remember 730 Driftwood, which is now a closed case, so I think I can talk about it. We had that property cleared, and after this meeting, if anybody wants to see the before and after pictures, I'd be more than happy to show them to you, but it was, you know, moving forward, it was one of my bigger cases that we were finally able to clear that lot off, and I think most of the whole mobile home park were out thanking us for doing it, so, and that's largely because that case went through this board, so I appreciate that. That's all I have.
Where was Driftwood?
It's in River Village Mobile Home Park. River Village Mobile Home Park's on Live Oak. You know where the trail goes east and west,
Yeah.
Diston,
Yeah.
east of the splash park. It's that little mobile home that borders right up on the river. So, and that one was, it was significant. It was big for me because it was the first one I really kind of tore down, although it was a mobile home. So it was a little easier. But thank you guys.
Does anyone else have anything?
Well, did you say that something was in red on our stuff?
I think, do you guys get something that looks similar to this and it has Beth?
Yeah.
Maybe Beth can help with this.
Is it in red?
'Cause I get a different version.
Yes, it is.
You get an edited version.
This is the first time we did it. Each one of the cases has what he's reading.
Oh.
That's a repeat violation one. So if you go toward the end of all your summaries, you'll notice some of the writing. I know last month's post ordinance meeting, you guys were talking about how with repeat violations, you know, that they could potentially be larger
have anything with red.
I don't know what you're talking about. I'm looking.
Me
It's
too.
a packet that came to us.
Today, when I gave you your agendas, I
Oh,
also gave you
okay.
summaries for every case that you just heard.
That's a little different.
That's different.
Yeah, it was not in my packet.
Okay,
Yes, I see what you're saying.
yeah.
It doesn't copy
It's not in there.
Oh,
but it's in the parentheses if I understand what she's saying. Yeah, see right there, there's a good example.
Yeah, it wasn't there.
$50 a
what
day.
does it say on the front of this?
Happy Thanksgiving. It's on, you wouldn't see it red because it doesn't copy it.
Okay, it doesn't copy in red, so we don't have any red.
This is what you're referring to right here, correct? Is that an example of the $50 parentheses?
Oh, because
It's in black.
When you printed it, it wasn't colored.
You're not an idiot, we just, I'm looking, she's looking for red,
Printed them in red.
and there's no red.
Remember not to make that, I'm sorry, this is the first time I did it. I was just thinking,
I
you
just-
actually print them in red, and then when I copied it, they're gonna be in black, unless I do it in color. So anyway, it just has, next to the repeat violation, and it will be in red for the next time, if you even want it. If you
Yes.
don't, I don't need to
I
do
do,
it.
I think it's a good idea.
It shows, how much they were charged, how much they were fined for the previous.
That'd be great.
I think it's good.
Good idea.
Good idea.
Thank you.
Sure.
I just want to say that this is my last meeting. I go off the board at this month, and I want to thank the board for helping me, and especially Mr. Trask. I know.
I'm sad. I did not know that.
And on that, seeing there's no more business, we will adjourn the meeting at 4:52.
But you'll be here next time.
December?
You'll be here, oh, you won't?
She has to be reappointed.